have the witness sworn in, Mr. Strange?
Yes, let's do that first.
Thank you very much. Please, could you do that, Meta?
Yes, Judge. Good afternoon, Mr. Al-Hassan. Can you please state your full name?
Qais Abu Hassan.
Can you please confirm if you will be taking an oath or an affirmation?
I will be taking an oath.
Can you please confirm that you have the Holy Book in front of you?
It's right here.
Can you please repeat after me? I swear by Almighty God.
I swear by Almighty God.
To say the truth.
To say the truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Mr. Hassan, we have some logistical issues that we need to cover with each witness. So I'm going to ask you some leading questions about where you are and what you have present. So my first question is this: other than the devices provided to you to see video and transcript and documents, do you have any other electronic devices in the room with you?
No.
Okay. And other than yourself, who is present in the room?
Katerina from King & Spalding.
So that's Katerina Frovlova, an associate from King & Spalding.
Correct.
Okay. You understand, Mr. Hassan, that Ms. Frovlova is simply there to assist you with documents and that you are not to ask her for assistance of any kind during the course of your evidence?
Yes, I do.
Do you have any notes or documents with you other than the trial bundles?
Absolutely not.
Okay. Mr. Hassan, I want to confirm your two witness statements. If you could please be given access to Bundle H and take up tab 18.
All right.
Could you please identify the document at tab 18 on the first page?
Witness statement of Qais Abu Hassan.
Okay. Is that your first statement that you filed in the context of the summary judgment proceedings on the 7th of March 2019?
Correct.
And if you could take up page 32, please.
7th of May.
Thank you. You correct me, which is a good sign. Could you identify that signature there, please?
Yes, that is mine.
Okay. And are the contents of that statement true to the best of your information and belief?
Yes.
Thank you. You're now going to be given the D bundle. Please take up tab 4 and identify that document.
Second witness statement of Qais Abu Hassan.
Okay, and page 33 or D96.
Correct. My signature dated August 26, 2021.
Thank you. And are the contents of that witness statement true to the best of your information and belief?
Yes.
Thank you. And do I understand it correctly that you do not have any changes or amendments to either statement?
Correct.
Thank you. So Mr. Montague-Smith, who's representing the defendant is going to have some questions for you. Just ask you to speak slowly for the transcriber and listen carefully to the questions.
Thank you very much. Hello, Mr. Hassan.
Hello.
Is that the right pronunciation, Mr. Hassan?
Correct.
Thank you. All right, I'll try and use that. Mr. Hassan, I'm going to be asking you some questions about this project in the DIFC, and I'm going to be asking you questions largely about the things that you've said in your second witness statement. So if you can keep that out in front of you, I'll probably take you to a couple of other documents as well as we go, but to have that to one side. But just to establish your the period for which you were involved in this project, you became involved in about May 2014. Is that right?
Correct.
All right. And so if we look at your second statement and we go to page D67, and you see there paragraph 8, and you state your impression about things that had occurred prior to your involvement. These are all matters that you have received information about from documents and from other sources, yes?
Correct. When I first got involved in 2014, I needed to get myself acquainted with the history of the matter. So in doing so, I read some of the document and I listened to various different versions from different people involved during that time.
Yes, and I think you say that at that time your impression was that Hexagon had seriously considered suing the DIFC in 2012, but was trying to negotiate a replacement. As far as you were concerned, when you came into this project, those were the two options being considered, yes? Negotiation of a different, of an amendment, or on the other hand, making a claim.
When I got involved in 2014, it was more of going to do a claim, because when I got involved in 2014, one of the principals of Hexagon, which is Mr. Abdullah Ramazan, informed me in one of the discussions that they had reached, they're not getting anywhere with the DIFC, and that they basically are getting ready to file a claim against the DIFC. So when I got involved in 2014, it was more geared towards filing a claim, although the window for negotiation was still open. But by that time, they had lost hope in the negotiations.
Right. But the negotiations were for a settlement of some sort, and they were for a different deal to the one that had gone before, yes?
Let me, if you will allow me, just to explain that when I first started in 2014, the position that I was informed of was that Hexagon had right to develop the property under a JVA agreement that was amended, and that was breached. And so when I got involved in the project, my involvement was to reach a settlement agreement. So in doing so, my understanding that Hexagon has reserved its rights. So anything that happened prior to my involvement was the dealings of the people that were involved before me, along with King & Spalding and the ultimate beneficiary owners. My involvement was limited from 2014 to try to reach a settlement agreement.
That's fair. All right. Well, let me show you paragraph 15 of your statement.
Paragraph
So
15.
Yeah, paragraph 15.
1 second. I opened page 15.
So just reading the first two sentences there, you say, as I mentioned in paragraph 8 above, Hexagon seriously considered filing a claim against the DIFC. At several points in 2012 to 2014, the DIFC was not negotiating with Hexagon in good faith. That is all a reference to the period before you were involved, yes?
Correct.
All right. And so from your own knowledge, you are not personally able to comment on whether or not the DIFC was negotiating in good faith.
Well, okay. I work with Abdullah Ramazan on more than one venture. And not only is he a business partner, he is also a family friend and a personal friend. So I see him quite often. whether for business or for social gathering. And in my meetings and in my relationship with him, usually, as you know, in this part of the world, it's just a general discussion. People, or at least me and him, we talk about what's going on in our businesses or in general. So the DIFC case, although I personally got involved in it in 2014, I've had heard of it. I had heard that they were frustrated. He explained to me a little bit about the history. So although before 2014 it was very general, I had an idea of a sort. But my involvement was from 2014 going forward. And in that period, which is 2012 to 2014, it was still very fresh when I started. So in any discussion that would happen during that particular period, when 2014 had, when I started in 2014, the events of 2012 to 2014 were still very fresh. So they were predominantly part of any discussion or explanation or whatever the correct terminology is, but any discussion or any meeting regarding this, the 2012 to 2014 was still relatively very fresh.
Right. But so the question that I asked you was about your own personal direct knowledge of negotiations with the DIFC. And all I was asking you to confirm was that so far as that knowledge is concerned, you did not have knowledge of negotiating with the DIFC for the period that you're referring to here. Yes?
I was
Direct
not involved.
Yes.
I was not involved, but I had knowledge.
So the answer is no, you did not have any direct personal knowledge. Is that right?
No, I did not have a direct involvement, but I did have the knowledge during that period.
Knowledge, but you'd had discussions with other people. So what you're telling me is that somebody told you about the history, and that is the source of your knowledge.
Yes.
I see. All right. Can I ask you about one thing? Now, Sheikh Mana became involved in this project in 2014, didn't he?
Can you repeat the name?
Sheikh Mana, M-A-N-A, or possibly M-A-N-E?
Can you help me refer to where or when or?
No, I'm asking. I said when. I said 2014. In early 2014, Sheikh Mana became involved in the project, didn't he?
I'm not sure who you're referring to as Sheikh Mana.
All right. Well, can you look at? So it's Sheikh Mana bin Hashir Al Maktoum. Are you aware of his involvement in the project?
No.
I see. So if we go forward then to page F1898, sorry, go in the bundle. So we're looking here, you'll need F4, bundle F, volume 4. Tab 241.
Okay, it's in front of me.
So do you see there in the middle of the page, there's an email from Omar Mohammed Al-Hamadi to Brett Schaefer.
Can you repeat the page number again, please? I'm sorry.
1898.
1898.
You see the page numbers at the bottom. They're on my version, they're in red. I don't know whether you have them in red as well. They're also at the top right.
1898.
1898 is.
Okay.
So do you see there an email in the middle of the page? Meeting request with Majid Al-Mari, replot PA01. And this is an email, it looks like an internal email from the DIFC's side, but it says, Dear Brett, as discussed, we have received a meeting request from Mr. Majid Al-Mari, advisor to Sheikh Mane bin Hashir Al Maktoum. As per Majid's advice, they want to discuss a pending issue regarding a plot in DIFC PA01. I believe this matter is also related to a Hexagon project, but we are not sure about the relationship, the relation between Sheikh Maneh and Hexagon. When you came into the project, were you aware that there was some sort of involvement by Sheikh Maneh?
I was aware that the beneficial owners of Hexagon had sought assistance from a high-profile person within the UAE government, Dubai, I don't know the correct terminology, and that he was trying to assist them to resolve the issue, but I did not know his name, and now that you're mentioning it to me, I'm understanding that this is the person that they had referred to.
I see.
So they were seeking...
Sorry, I interrupted you. Carry on.
So they were seeking through various means to try to reach a settlement agreement.
So your information about the involvement of Sheikh Maneh comes from your discussions with Mr. Romaizan and the other shareholders?
Particularly Mr. Romaizan, and my understanding was limited to the fact that they were trying to various channels to get to the DIFC to reach a settlement to the issue they had in the DIFC.
All right. When you had those discussions with Mr. Romaizan, did you talk about Sheikh Maneh having an agreement, for example, some sort of contract with Concept Holdings?
No.
Can I ask you to turn back in the F bundle, please, to page 1868? Tab 234, thank you. 1868. This is an email from before your time.
Mm-hmm.
I just want to show you what it says and then ask you about it, if I may. Do you have that?
Yes.
So this is an email from Mr. Jawad Ali. You know who Mr. Jawad Ali is, yes?
Correct.
He's the lawyer at King & Spalding, and he's emailing Mr. Abdulaziz, but he copies in various other people, including Mr. Romaizan. Yes? Do you see that?
Correct.
All right, and he says, Dear Abdulaziz, I hope this email finds you well. As promised, attached is the authorization letter that you requested. And he says, while we thought it was okay for CHL to enter into an agreement with Sheikh Maneh, as this agreement will not be shared with the DIFC, we believe that an authorization letter given to Sheikh Maneh should be granted by Hexagon and CHL, so as not to give DIFC any further evidence that Hexagon had accepted the termination of the original contract. So this suggests, doesn't it, that there were at least discussions between CHL and Sheikh Maneh about entering into some sort of contract. Now, when you spoke to Mr. Romaizan, did you discuss anything like that?
No, and as I mentioned earlier, my information from 2012 to 2014 was very high level. I did not have the specifics, and which is what these documents and these agreements that you're referring to, I was not part of any of these. I was part of a general, I was informed in a general format of the events of 2012 to 2014 and not the specifics. So therefore, I am unable to comment on any of these.
Well, I'm asking you about, I'm not asking you necessarily to comment on the email. I'm asking you about the information that the email seems to convey and whether or not that is consistent with your understanding when you came into the transaction. So don't worry about the fact that this email predates your time. But you've given me your answer. Yeah.
My information from 2012 to 2014 was on a general level, and I was unaware of these specifics.
I see. All right. Let me ask you about something else that arises in this email, if I could. Do you see where we left off in the email? If you skip a sentence because it's not necessary, and then it says, furthermore, we feel it is very important to reference the last letter we sent to the DIFC on this issue, so we make sure that if the negotiations fail, this will be the basis for any claim. Of course, we can explain to Sheikh Manna that ultimately what we are interested in is a new joint venture along the lines outlined in the CHL agreement with him, but that for the record we need to maintain our original position in case his mediation fails. Now, you were in charge of the negotiations. Is it right that in those negotiations you were trying to achieve an agreement with the DIFC which was along the lines of some agreement that had been entered into between CHL and Sheikh Manna?
I'm going to split my answer into two parts. First of all, when you're referring my involvement was from 2014 onward. What you're taking me through here is from 2012 to 2014. When I got involved in 2014, the position was as follows. Hexagon had reserved its rights against the claim, for the claim. And my position or my involvement was to reach a settlement agreement. So the first thing that we did when I started was we worked on, or one of the first things was we worked on the standstill agreement. Because throughout the discussions from when I started, okay, the issue is that we had reserved our rights, and we wanted to make sure that our rights were reserved throughout the period that I was negotiating through, because my negotiation is a settlement agreement.
The standstill
So
agreement.
whatever the settlement agreement results in, whether it's a new joint venture agreement or a term sheet or an amended JVA, this is a result of the discussions of a settlement agreement. The original agreement and the JVA as amended and the breach that followed, all of these rights were reserved. So in the middle was me. It was either we'd reach a settlement agreement or they'd file a claim. And my mandate was strictly focused on reaching a settlement agreement.
Thank you. A couple of things that arise out of that. Firstly, you said the first thing that you worked on when you arrived was a standstill agreement. In fact, the standstill agreement was...
I corrected myself immediately and said one of the first things that was worked on. When I say worked on, that was collectively, the people involved at the time was myself negotiating a settlement agreement and King & Spalding from the league as a legal advisor. So King & Spalding's concern at the time was to implement the standstill agreement to ensure that our rights are reserved throughout the negotiation period. They were not going to let me to go on negotiating without reserving the rights and doing the standstill agreement.
Yeah, I'm not trying to trip you up, Mr. Hosson. I'm just trying to show you the chronology. The standstill agreement was first suggested in November 2017. So more than 3 years after you came on board with the project. So are you sure that you are remembering rightly when you suggest that one of the first things that was going on, at least, when you joined the project, was the preparation of the standstill agreement?
Let me, it's not correcting it, but in the time frame of things, when I got involved, it took a long period of time between when I got involved and things started to actually happen with the DIFC. So the first thing, if I'm correcting, so the first thing that we started doing when the DIFC got back on the table was negotiate the standstill agreement. But there's a period of time from when I started up until we got DIFC on the table, which elapsed. So there is a gap between those two.
So are you saying that sitting here today, you don't think much of any importance happened between you coming involved in the project in May 2014 and discussions in relation to the standstill agreement.
Can you repeat your question?
I'm just asking you about your recollection as we sit here today. We can all look at the documents, but just in terms of your recollection of your involvement. As I understand your evidence, your position is that between the time you came on board and the time that the party started looking at a standstill agreement, not an awful lot of importance happened between the DIFC and Hexagon.
The standstill agreement and what it represents, I'll leave that for the legal to decide and reply to you. From when I got involved, the sequence of events that happened from when I got involved is that we raised this case to Her Excellency Reem Al-Hashimi. And the reason we went to Reem, to Her Excellency, and presented this case for more than one reason. But of the reasons that we approached her is because we wanted a recognizable person from the government of the UAE, from the Dubai government in particular, independent from the IFC, who cares about the reputation of the DIFC and the reputation of the Dubai and cares for the investors, to actually have a look at this case before we go to court.
All right, I'll ask you about
There is
that.
a lot.
Yeah,
there is
I'll
a
ask
lot
you.
of relevance between the countries that period.
All right, thank you. All right, well, we'll come back to the letter in a moment, but just to understand your position and your role, you're saying that you were appointed in effect to negotiate a settlement agreement, yes? And in that settlement agreement, the joint venture agreement that had been agreed in 2003 and 2004, and the breaches of that agreement that you saw, that your instructing people thought had occurred, all of that in a sense is in the past, isn't it? And not necessarily going to form the basis for your settlement negotiations.
No. The history is not in the past, okay? But this is two separate channels. The rights and the reserve and the legal channel has always been there. In parallel was my negotiation or my intervention to negotiate a settlement agreement. In order for me to negotiate the settlement agreement, we are discussing the right that we had under the joint venture agreement to develop the property, or the right that Hexagon had. So this was the basis of the settlement agreement. So the split in roads, okay, but yes, the JVA as amended has a lot of relevance because it is the basis of this agreement. That's the basis of the relationship between Hexagon and the IFC.
All right. But the settlement that you were seeking to agree was a contract for the terms on which Hexagon would develop this project, yes?
Can you repeat the question one more time?
So the shape of the settlement that you were trying to negotiate wasn't, for example, a lump sum of cash. What you were trying to negotiate as a settlement was a contract for the development of the plot.
Correct.
All right. And this email suggests that at least in September 2013, the intention or the aim of those discussions was a joint venture agreement along the lines of an agreement to which Concept Holdings was a party. Was that also the intention when you were involved?
Absolutely not.
I see.
Because one of the things that was agreed upon very clearly when I got involved between the IFC and Hexagon's legal teams, okay, was that the CHL agreement, okay, was not enforceable. This was crystal clear. It was never part of our discussions. It was never brought up in a way of negotiations, because both parties had a very clear understanding that this was not enforceable, executable. You use the legal terminology that you would like, but from me as a business person, when I started the discussions and the negotiations, this was the position that I was negotiating from.
Yes, but I think what I'm asking you about is the position you were negotiating to, and is it right that you were trying to negotiate towards a conclusion, a concluded agreement, which contained elements from some agreement that CHL was a party to?
Absolutely not.
I see. All right. Now, you mentioned the next substantial thing that happened after you became involved in this was that you sent a letter to Her Excellency Al-Hashmi, the Minister of State, yes?
Yeah.
And do you remember that that letter was sent, I think you say, on the 23rd of October 2014, yes?
Can you give me a reference so that I can open it?
Yes, I'm going to be working from a translation and I'm not sure there's a date on it, but if we go to bundle F, volume 3, I think it is, and it's tab 246.
You have it?
And in fact, the Arabic is there.
It's volume 4.
I do apologise, volume 4, thank you. All right. And do you see there, that's the letter. I'm afraid, as I say, I'm going to have to work from the translation, which starts on page 1914.
No problem.
All right. Now, the purpose of this letter was to ask Her Excellency to intervene on behalf of Hexagon, wasn't it?
It was to get involved to resolve the dispute on behalf of Hexagon and the IFC. I mean, we were presenting to her, but we wanted a solution, and it was in the interest of both parties to reach a solution. But
Yes.
At least that's what we had envisioned.
So you wanted to encourage her to intervene into the dispute on behalf of Hexagon and take up the issue with the DIFC, yes?
Correct.
All right. And so you must have known that the contents of this letter would be communicated to someone on the DIFC side, yes?
Not necessarily, because what we were intending from this was to give her, for her to be informed. What she was going to do, we are unaware of it. Whether she would pick up the phone and make a call, she would send a letter, she would send an email. I'm not sure what she would do. But the purpose of this was to send it to her so that she can get a picture or draw an understanding of what the situation was at the time.
Well, isn't it right that part of the purpose of this letter, of sending it to her, was that you wanted her to take the information and communicate it to the DIFC?
No, because it was up to her what she wanted to do. We were getting her involved to resolve the issue. What she was going to go do with this information was something that she would decide. I mean, there were many options. She could have escalated this to the level of Sheikh Mohammed. She could have went and spoken to the DIFC. She could have sent email. I don't know what she was going to do with it.
But you had a dispute with the DIFC. You get her involved in that dispute. You write her a letter containing various information. Surely you wanted her to communicate with the DIFC about the things that you'd written in your letter. What you wanted. I'm not asking what she would have done with it. You can't control it. But what you intended.
I wanted her to go and discuss this issue with the DIFC to reach a settlement.
And you wanted to remind the DIFC that Hexagon considered that the original joint venture agreement was valid and binding, didn't you?
That was our position all along, that it is valid and binding, whether to her, to the DIFC, or to any person involved.
But the purpose of this letter and sending it to Her Excellency, your intention was that she would take this information and communicate to the DIFC that Hexagon did consider the joint venture agreement was binding, yes?
Again, I don't know what she would do. My intention was to get her involved to resolve the dispute. What information she would pass on, I do not know.
Yes, of course you can't control what she does. But I'm going to try one last time. And can you just listen to the question? And you may disagree with what I'm suggesting, or you may agree with it, and that's fine. But just let us know, and please answer the question. Did you write the letter in order to remind the DIFC that Hexagon considered that the JVA was binding agreement?
I'm going to repeat the same answer. I did not write the letter to transfer information to the IFC via Her Excellency. We wrote the letter to make her informed of what was happening, and what she was going to do is not something I would know.
Can I ask you to look at paragraph 17 of your witness statement, please?
Yeah.
And there you say, in writing the letter, Mr. Romazan simply wanted to negotiate an amicable solution, and this is the bit that I've been asking you about, and remind the DIFC that Hexagon considered the JVA as amended to be valid and binding. So, is that accurate?
Yeah, but if I read here again, in writing the letter, Mr. Romazan simply wanted to negotiate an amicable solution and remind the DIFC that Hexagon considered the JVA as amended to be valid. That was his intention.
That was what I was asking you about. You were involved in the letter, weren't you?
Yeah, but you were saying that we wrote the letter so that she can go and inform the DIFC or remind them that this is legal and binding. This letter is to her. He wanted to show her and explain to her that we wanted to negotiate an amicable solution.
And remind the DIFC.
When she gets involved with the DIFC would come to the term that we are still pursuing our rights under the JVA. We did not give up on trying. That's the intention.
How could you have intended for the letter to remind the DIFC that Hexagon considered the JVA to be valid and binding, unless your intention was also that she would communicate the contents of that letter to the DIFC?
Because we wanted to show the DIFC that we were not giving up and we were still seeking every single form for them to allow us to implement our right to develop the land under the JVA as amended. And one of these trials, or one of the attempts, was to go to Riem al-Hashimi.
Can I ask you to look at the letter again, please, if we go to page 1915 this time? Do you see there the second bullet? Yes, please. Do you see there the second?
I'm there.
Do you see there the second bullet point on that page? Yes, the second dash. It says this. Yeah. DIFC Investment Limited did not raise any legal objections to our contract with them for many years, and they dealt with us as partners, but they did not settle on a decision regarding the purpose of development. At one occasion, they would decide on offices, another on hotels, and another on a multi-purpose complex. And each time they would revert back with new designs, preparation of which had costed us huge sums of money and a loss of the valuable time to commence the work. Now, as a matter of fact, the fees incurred for design work had been wasted because the designers themselves had been unable to come up with a design which met efficiency requirements. Were you aware of that?
This clause refers to a period of time that was preceding my involvement, so I'm unable to answer to the particulars of that.
I see. All right, let me ask you about something else then. If we go over the page 1916, And do you see under there's a paragraph that starts based on the above?
Correct.
And you say, and Mr. Ramazan says, please allow me to clarify to Your Excellency our position. And do you see then under the next bullet, I won't read the first sentence, I don't think we need to, but we can say, so for the third line down in the middle, more importantly, from the beginning, we only wanted to implement the project to the satisfaction of His Highness and open new paths for larger and more important future projects in various sectors of Dubai.
Sorry, I'm going to interrupt you. Can you take me to that? I did not see where that is.
Oh, I see.
More importantly.
Yeah, so you've got more importantly from the beginning, we only wanted to implement the project to the satisfaction of His Highness and open new paths for larger and more important projects in various sectors of Dubai. Does not this deliberation of patience require a professional and transparent response, and so forth? So in this letter, you were telling Her Excellency, at least, that Hexagon's intention was at this point to proceed with the project, yes?
If we were allowed to develop the project, yes.
Yes. And so then you say in the second bullet point, if the response is positive.
Sorry, I'm cutting you. This is a letter written by Sheikh Abdullah. It's not me saying.
I thought you said that you had a hand in the letter.
I had a hand, but I'm not. This is not me. This is signed Abdullah Muhammad Al-Rumaizan.
I see. So are you saying that you don't know what he was thinking at the time?
If you can take me through, I'll give you my answer to the best of my ability.
No, but I'm asking you about this letter. You've intervened to say it's not your letter. Are you making that intervention because you're saying you don't know what Mr. Ramazan was thinking at the time?
I knew the essence of his thinking. I knew the nature of the letter, but this letter was sent in Arabic between two GCC nationals. So to take the letter in its context, you have to understand the local traditions and means of communications. So a lot of things that are written here are from the standpoint of protocol and local interaction or local ways of dealing. So I'm happy to go through the rest of the letter with you.
So are you suggesting that you are not the best person to be asking about this letter and we really ought to be talking to Mr. Ramazan about it?
I am the best person at that point in time that had the whole history from 2014 up until 2018. This is very particular to the letter. I was informed, I have the information, I have the general knowledge, but I'm also adding to this that this letter was sent between two high-profile individuals, and the nature of the letter includes details and protocols that are not strictly of a business matter.
Thank you. Well, I won't trouble you with the rest of the letter. Let's go to your witness statement, please, at paragraph 18.
All right.
Now, you refer to one aspect of Mr. Ramazan's letter here, and you point out that, I'm looking 5 lines down from the top. You say, in this context, Mr. Ramazan's reference to immediately inject the required capital in the letter obviously took into account any time required to arrange financing. So thinking back to your involvement at this time, it was planned, wasn't it, that Hexagon's investment in this project would come from borrowing, yes?
With regards to the financing of the project. Okay.
Yes.
There are 3 parties involved, and each party in its own can finance or find ways to finance the project. But I will speak on what I know, which is Mr. Romazan. Okay.
Yeah.
Just for the history about all of this, because even in my dealings with the IFC, it was brought up more than once. In the negotiations, it was brought up more than once, and we were always assuring them that the issue of the financing is not an issue for us at all. Mr. Romazan himself, with projects relating to us in Qatar, was able to finance based on a personal guarantee. And in Oman, he did the same. So financing for him, or providing the finance, is the simplest and most basic thing. Anybody that would do the most basic due diligence on Romazan would see that he is more than capable of financing this project. So when we say financing the project, they are able, willing, and more than capable of doing so at any given point in time.
So that's not the question that I asked you, and I'll come on to it. But if I can just ask you to listen to the question, maybe answer that. You refer to a statement in the letter where Mr. Romazan had said, we will have no, if the response is positive, we have no choice but to start work and immediately inject the required capital. You commented in your statement on what he meant by that, and you say that his reference to immediately inject the required capital obviously took into account any time required to arrange the financing. So at the time the letter was written, the intention was to invest, first to arrange financing, to obtain financing in order to invest, yes?
Financing was one of the options. But when we say financing, it doesn't mean bank financing. It could be financing from their own money. It could be more than one way, but it takes into account the time needed to arrange the financing. That's the literal context of the sentence.
All right. Can I ask you to tell me about something different, please? If we go to paragraph 19. And you say, after receiving the letter, I believe that Her Excellency Al-Hashmi initiated contact with the DIFC and played a part in arranging a subsequent meeting with the then governor of the DIFC, His Excellency Yasser Kazim. Hexagon heard nothing more until the meeting with Governor Kazim was finally arranged, the exact date of which I cannot now recall. So you then say, in the next paragraph, paragraph 20, another meeting took place on the 6th of July 2015. King and Spalding attended on behalf of Hexagon, and Hamed Kazim attended on behalf of the DIFC. So just asking about the meeting with the governor. The meeting with the governor came after the letter that we've just looked at, but as far as you can recall, before the meeting in July 2015, is that right?
I'm sorry, but the internet cut. I didn't hear the second part of the question.
I'm asking about the timing of the meeting with the governor. As far as you can recall, that meeting with the governor that we've just seen you refer to came after the letter to Her Excellency,
Yes,
but before the 6th
correct.
of July 2015 meeting with the DIFC. Is that your recollection?
Yes, that is my recollection.
Can I ask you to pick up bundle J, please, and turn to tab 12?
What was the...
Do you have tab 12? Tab 12 in that?
Okay.
Yeah. So we see there a letter that's in Arabic, but I'm going to ask you about, again, the English translation, which you'll find on page 117. And do you see that is a letter to the governor of the DIFC, and it's signed by Mr. Al-Romaizen, again, at the back?
Correct.
Yeah. Now, the letter itself comes from a later date, but I just want to show you what it says about this meeting. Do you see there in the third paragraph down, it says, as per our first meeting in September 2015.
Just a second, let me find that.
The third paragraph down. As per
the first meeting. Oh.
So do you think perhaps that the meeting with the governor that you have described, in fact, came in September 2015?
As I said in my witness statement, I don't recall when exactly it happened.
I see. So it's fair to say that your recollection of the meeting is relatively hazy, is it?
No, the recollection of the meeting is not very hazy. I just don't remember when the meeting itself happened.
I see. But all right, and then what it says is, as per our first meeting in September 2015, and our agreement that the above contract is ongoing, binding, and enforceable, and must form the basis of Hexagon's relationship with DIFC Investments going forwards, and then refers to a draft term sheet which we'll come on to. So your position and the position of Mr. Romaizan at the meeting with the governor was that both parties wanted to carry on with the original JVA. Is that right?
No. We came and we said that we had our rights under the JVA, and the governor himself said that we would continue, but there would be some minor modifications. Those were the exact words there. So we did not come out with a clear and vivid understanding that they were proceeding with the JVA as amended.
Well, it refers in this letter to the agreement that the contract is ongoing, binding, and enforceable. So are you saying that it was not in fact agreed at that meeting that the JVA was ongoing, binding, and enforceable?
That's exactly what I just said. The governor acknowledged our rights, but said that there would be modifications.
Well,
And particularly, he mentioned the percentages.
Now, in fact, the options that were under discussion at that meeting were, well, there were two options, weren't they? One was you were discussing the possibility of a sale of the plot to Hexagon, and the other was the possibility of proceeding with the joint venture agreement. Yes?
When we went to the meeting, our intention was to reach a settlement agreement. In the meeting, the purchase of the land was proposed as an option by the governor for us to look into.
All right. Let me ask you about the next meeting in paragraph 20, or the meeting that you said came after, but in fact looks like came before, the meeting on the 6th of July 2015. Now, do you see that in your statement at paragraph 20? Yes.
Paragraph 20, yeah. Go ahead.
Yes, so you say in the third line, talking about this meeting, at the end of the third line, you say, I cannot now recall for sure, but it is likely I also attended this meeting. So if you can't remember whether you were there, presumably you really don't have any recollection at all about what was said at the meeting.
No. First of all, this meeting is with Hamid Kazim, so it's not the governor. So we're referring to two different meetings.
Yes, I said a different meeting.
People.
I was asking about a different meeting.
Okay. And regarding this meeting, at that time, anything that was happening in terms of meeting was immediately communicated between the parties and we would update each other on what happened. So had I attended the meeting, I would have had a clear recollection, and had I not attended the meeting, I would have been briefed very in a lot of detail, enough for me to know exactly what happened in that meeting.
I'm asking about your recollection now. Yes, you understand that, yes?
Yeah, I do not recall if I attended the meeting, and you asked me if I recall the events of the meeting. So I'm explaining to you, if I do, how I would have a recollection.
Well, you either have a recollection or you don't have a recollection. As a matter of fact, sitting here now today,
I have a recollection.
You have a recollection of the meeting.
I have a recollection of what happened in the meeting, but I'm not sure if I attended this meeting.
I'm just trying to understand how one can remember what happened in a meeting without remembering whether you were actually at it. If you can remember, for example, someone saying something to you at that meeting, then that would mean you remember being at the meeting, but you don't remember anything anyone said to you at that meeting, for example.
I don't recall, but I can. What I'm trying to explain to you is that when the meeting was over, in all the meetings, this was what was happening. We would brief each other in full details.
I'm not suggesting that had you attended the meeting the following day, you would have forgotten all about it. What I'm asking you about is your recollection today. That's all. And don't get me wrong, I'm not criticizing you for being unable to remember the details of a meeting which occurred 7 years ago. I'm just trying to establish what you can remember and what recollection is based on documentation. So is it fair to say that sitting here today, you don't have any recollection of what happened at that meeting?
No.
It's not fair to say that, or you don't have it?
No, it's not fair to say that I don't have a recollection of the meeting.
Right, I'll leave that there. Can I show you a document that is not one that you were party to, but it summarizes what happened at the meeting, and then I'm going to suggest that it's accurate. If we go to page 1934, please. It's behind tab 248, and it'll be in volume 4 of bundle F.
One 1934.
Yes.
Okay.
Do you see that? And do you see paragraph 6.2? So again, this is not a document that you were party to, but it records some of the history. And it says at that meeting, and you'll see the meeting that's being referred to as the 6th of July 2015. At that meeting, 2 options have been presented by DIFC Investments for further discussion. Option 1, DIFC Investments would make an outright sale of the plot to Hexagon instead of proceeding with the joint venture structure. Option 2, DIFC Investments would honour the principle of the JV agreement on terms and conditions to be agreed by the parties, and then says the term sheet was then subsequently given to King and Spalding for their consideration. So as far as you are aware, that is an accurate statement of what was discussed at that meeting, yes?
Among the things that were discussed, these were the options provided to us from the governor. So we, by default or by naturally, they went into the meeting discussions or the discussions that we had with the DIFC.
I see. So you do accept that even in the meeting with the governor, there was discussion about these 2 options as well?
In the meeting with the governor, we went in, and I already explained this position, but I'm happy to repeat it, that he acknowledged our rights. He said that there would be modifications, and in that meeting, he proposed that we buy the land outright.
I see. All right. Now, in relation to that second option, buying the land outright, can I show you paragraph 22 of your witness statement, please? So in the middle, you talk about...
Can I read?
Yeah, if you want to read the paragraph, that might speed things up.
Yeah.
Yes.
Allow me to read the paragraph.
Let's do it.
All right.
All right, so you say that the DIFC offered to sell the land in effect at market price, and you said that that was unfair because some sort of discount should have been offered to reflect the price paid for the shares in Hexagon, yes?
Correct.
All right, and that aspect of it, getting some sort of compensation for the price paid for shares in Hexagon, was something which was important to Mr. Romaizan, wasn't it?
No. What it is here is we have rights under the JVA, which we believe are favorable terms, and we were happy to execute. And the beneficial owners of Hexagon really believed in this project and really believed in what this project could represent. Don't forget that they were very interested to develop this project and to own a part of this ongoing development that is happening. So when you come and you say, okay, forget your rights under the JVA agreement and come buy the land outright at current market value, it's completely ignoring the history you have, the breach that's happened, and the rights that you have under the joint venture agreement. So if anybody walked into the door of the DIFC and asked to buy that property of land, he would have been given the same terms or the numbers that we were offered at that time.
So the question was whether or not, in reaching an agreement with the DIFC, it was important to Mr. Romaizan that there should be some reflection in the arrangement which took into account the sums that he had paid for his shares in Hexagon. Do you agree with that or disagree with that?
I will repeat what I said. Mr. Romaizan,
answer the question.
I cannot agree or disagree. It's not a black and white question. Mr. Romaizan paid for rights under the JVA agreement, okay? And he's giving up these rights.
Can I just suggest to you that from what you are aware of Mr. Romaizan's attitude to all of this, any arrangement which failed to take into account the sums that he had paid for his shares in Hexagon would have been unacceptable to him, yes?
Absolutely not.
Can I ask you
and
to
just,
go?
Just, please allow me to say that in I'm sure we're going to get into these later, but in the models that were presented by Deloitte, we asked them to remove the sums that were paid.
Well, can I ask you to pick up bundle J again, please, and go to tab 12? You may still have it open because it's the letter that we were just looking at.
Okay.
And do you see there the letter J117 that we just looked at, which is a letter to the governor from Mr. Romaizan? And if you turn over to page 118, it's 118, please. Do you see it? And this is the second.
I was completely disconnected for 10 seconds. So can you please?
All right. Well, I'm taking you to a document. It's bundle. Do you have bundle J, tab 12?
Yes.
If you turn, please. We looked at it a bit at page 117. Do you see that?
Correct.
And that's the letter to the governor from Mr. Romaisan that we talked about, yes?
Correct.
And then if you turn over the page, at page 118, and I want to look at the second paragraph with you. The letter says, it was only recently following Mr. Gaith Abu al-Hosn meeting with you on the 15th, 16th May 2016 that my legal representatives were invited to meet with Mr. Visser on the 18th of May 2016. In the event, and despite your assurances that things were moving in the right direction, this long-awaited meeting was extremely disappointing. Mr. Visser did not provide the long-promised comments on the term sheet, but my legal team was instead told that we need to start from a clean slate and make a proposal based on the existing contract, but with market rates, apparently wholly ignoring the original and significant amount I and my partners had paid with respect to the contract, which is a matter that is unacceptable to us. So I'll ask you the question that I asked you earlier just one more time. Would you accept that any arrangement with the DIFC which failed to take into account the sums that Mr. Romaisan had paid for his shares would have been unacceptable to him?
And I repeat my answer, no.
Well, aren't you saying something, or isn't Mr. Romaisan saying something quite the opposite in the passage that we just read?
That was basically the same thing that I just explained to you, that they were offering the land at market rate, and we had the right under the joint venture agreement to develop the land. So we're giving up the rights and the history and the breach for a land that's being proposed to us at market rate.
But he's saying that if it was the feature of the offer that made it unacceptable to him was the fact that it wholly ignored the original and significant amount he and his partners had paid with respect to the contract. So in other words, the money he spent on the shares was being disregarded in the deal, and it was that he was saying was unacceptable to him. In your understanding of your dealings, just wait for the question. In your understanding of your dealings with Mr. Romaisan, that was his position, wasn't it?
First of all, allow me to read the sentence, and then I'm going to answer you immediately, but I just want to clarify something in the reading. Here is referring to the market rates which were offered for the land. That the IFC wanted to sell us the land at market rate, which is for him is unacceptable because it didn't take into consideration the history and the amount that had been paid prior to this offer being made.
Yeah, I think in fact what he's discussing is proceeding with the joint venture agreement, but basing the shareholding split on market rates for the land. Do you recollect that?
This is a different subject. This is not about the purchase of the land outright.
Yes. All right. Well, we'll come back in the chronology to that particular meeting in due course. But just sticking with this offer to sell you the land at market rates. Now, you say in your statement that you felt that that offer was not a genuine offer. Now, what you really mean by that, though, is that you did not think that it was a fair offer. Is that right? Do you understand the distinction?
Not really.
We'll put it like this. It was a genuine offer in the sense that if Hexagon had agreed to buy at that price, then as far as you were aware, the DIFC would have sold at that price, yes?
At that, it's cutting, the connection is cutting.
You're not saying, so what I'm saying is, as far as you were aware, if Hexagon had agreed to buy at that price, as far as you were aware, the DIFC would have sold at that price, yes?
They would, of course, they would have sold because they're selling it at market rate and getting rid of all the history.
Yeah, so it was a genuine offer in the sense that they meant what they said, yes?
Can you go on? So you're saying you're trying to distinguish between fair and genuine? I'll tell you what my understanding is, and you can translate it whether it's fair or genuine. My understanding is that this offer that they're proposing to us, which is to buy the land at that price, okay, is not a fair offer because it doesn't take into consideration its history. Had they been genuine about this offer, they would have considered a different amount, which would be reasonable to the history of the project. So in a sense, I don't want to, you want to call it fair, genuine, I don't know the legal terminology that you're trying to, but what I'm saying is that it's an offer that we could not accept because they're treating us like anybody that just walked in through the door.
So just to finish that off, when you criticize the DIFC for not taking genuine positions, for not acting in good faith, for those sorts of things, is it right to say that your real criticism is that you thought that they were not making fair offers to your client? We lost you, Mr. Hodson. I think the connection's died. So, Mr. Hodson, I think you're back. I just have one more question. We're due a break for the stenographers in any event, but perhaps I can just ask this one more question again. When you criticise the DIFC and say that it wasn't making genuine offers, it wasn't acting in good faith, is what you really mean that it was not offering things that were reasonable? Is that what you're really saying?
Well, it depends on the situation and the circumstance in which I said what I said. So I cannot make a general statement.
All right, well, I'll come back to the particular statements that you make in due course. My lord, I think we are due a break for the stenographer now. Is now a convenient moment for 10 minutes?
Yes, we'll have a 10-minute break now. Mr. Hodson, because you're in the middle of giving your evidence, you mustn't talk to anybody else about the case or about your evidence in it. You understand?
I understand.
Thank you very much.
My lord, I will continue.
Yes, please do.
Mr. Hodson, we spoke about the July meeting, and you'll recall at the July meeting or shortly afterwards, the DIFC provided a standard form term sheet for discussing the arrangements going forwards. Now, in response to that, would you accept that Hexagon delayed in responding?
No, I don't know the exact time period that you're referring to.
I'm talking about the time period after the meeting on the 6th of July. So do you recall there's the 6th of July 2015? Yes. Correct. And if we go to your witness statement, paragraph 21, you say, the following day, Mr. Kodabaksh sent an email to King & Spalding attaching a copy of the DIFC standard form term sheet. So that's the 7th of July. And then there's no formal response to that until the 8th of October, when you provide a term sheet. Yes?
Yeah, but in that same meeting, if you read the paragraph, they also asked us for the details of the Hexagon shareholding. So we provided them with all the details, something that they've done maybe 5-6 times before, I don't know how many times, endless time. So we provided them information, and we got a very standard term sheet that the King & Spalding had to integrate so that it becomes relevant to the project, and then send it across.
Yes, so it took 3 months to prepare that term sheet, yes?
It took 3 months to, and two things. First of all, we provided them with the information regarding the Hexagon shareholding, and at the same time, they prepared the term sheet. It took 3 months. Yes, that the dates show it took 3 months.
If we look at Mr. Ali's email, you will find it in bundle F, volume 4, tab 250, page 2018.
Yes.
So you see there the email, that's when the term sheet was provided, and Mr. Ali says, we apologise for the delay in getting back to you since our meeting back in July. So do you accept that there was some delay in responding?
I'm not entitled to say whether there's a delay or not, but it's clear that during that period of time, there was two things happening. We were also actually looking at buying the plot outright in parallel to the working on the term sheet.
So in your view, all right, well, let's leave that. Now, so the time that was taken was to consult with all the partners regarding the offer to sell the plot to Hexagon outright rather than to enter into a joint venture to develop the same. Was there some disagreement between the shareholders as to the commercial position that should be taken in response to the DIFC's proposals?
No.
All right. Were there any disagreements on the commercial points between the shareholders?
No.
I see. But nevertheless, by the time we get to October, then your side is confirming that they want to go ahead with the original. Sorry. He says, Mr. Romazan, I'm instructed by Mr. Romazan that he and his partners have decided that they would like to implement the original agreement with the DIFC and enter into a joint venture to develop the plot. So was it in fact Mr. Romazan's instructions to implement the original joint venture agreement?
It was Mr. Ramazan's instructions to King and Spalding to proceed with the joint venture agreement and not buy the go to the option to buying the plot.
All right, and then if we go forward to tab 255, which I hope is in the same bundle. I think it is. And page 2077. Do you see there an email from Mr. Sachs? In fact, this email comes before the October email and might explain what was going on while that one was being prepared. Do you see it says, please note that we have prepared a draft term sheet regarding the Hexagon project and are finalising a couple of commercial points with our client and hope to be able to share it with you shortly. So is it in fact the case that there was discussion about the commercial points between the shareholders, at least at that stage?
Well, I cannot recall the exact events relating to this email and the commercial point, but during that time, the original discussion with the shareholders, whether we go back and negotiate with the DIFC to buy the land outright, and when I say go back to negotiate, the price that they have offered for us was unreasonable. But at one point in time, the shareholders thought, do we go back and negotiate on the price as a concept? So, or do we continue with the joint venture agreement? And so that was what they opted. So if that's what meant by commercial points, was whether we go for this option or that option, I'm not able to say because I'm not the one who wrote this email. But I can tell you that that was the spirit at that time. They were thinking strategically, are we going to back to negotiate buying the land, or are we going to negotiate a settlement agreement to the joint venture agreement that we had?
Can I ask you to look at the term sheet itself, please, that was sent? Now, I have various copies in my electronic bundle, some of which are corrupted. So I'm going to refer you, please, to tab 251 of the bundle.
All right.
can work from that if that's all right. And if you go forward in that tab to 2032, you'll see a copy of the term sheet.
Correct.
And you recognise that, yes?
Yes.
And you'll see the date of the draft is 8th of October. On mine, unfortunately, the page number has eliminated it, but I think everyone agrees that's 2015. Yeah. All right. Now, you are familiar with the terms of this term sheet, yes?
Yes.
All right. Now, would you accept that this term sheet proposed terms which were quite different from those in the joint venture agreement?
Okay, now with regards to the negotiation process, we are negotiating a settlement agreement. So in our, or at least me as a business person negotiating, I am proposing things that would be of benefit to the project. It's up to the IFC to accept or refuse or not accept. So what I'm proposing here is a list of many things, but none of these are prerequisite. This is an ongoing discussion for a settlement agreement. I propose what I have. They come back and say, okay, I'll accept this term. I won't accept this term. What we are firm and sure about is the JBA as amended. This is the cornerstone to everything. Everything over and above this is a negotiating point between the parties.
Yes, but I'm asking you about the terms that you are proposing at this stage, and you've given me your reasons, but I just, and so I take it that you accept this, that the terms which you were proposing in this document were different from the terms that you would find in the joint venture agreement.
No, what I'm saying is very clear. There's the joint venture agreement, which is very clear. We are putting around it, or we're trying to make a mechanism and agree on terms so that we can execute this joint venture agreement. So the terms we are putting here is what we are proposing. They're not amendments. They are propositions from us for a settlement agreement. So they can accept them or not accept them. But this is a negotiation between the two parties to reach a settlement agreement.
No, I
And
understand.
As I mentioned earlier, this settlement agreement, whether it results in a modified joint venture agreement or a new joint venture agreement or an agreed term sheet, this is the result of the negotiations.
Yes, but if what I'm trying to get to is this: if the DIFC had come back and said, yes, we agree to all of these terms, then that would have resulted in an agreement which was different in many ways and inconsistent with the joint venture agreement, wouldn't it?
Again, I'm repeating the same thing. This is a settlement agreement. If the IFC accepted it or didn't accept it, it's up to them.
That's not the question, Mr. Hostin.
But there's something that needs to be clarified during this period that we are negotiating, is that DIFC and Mr. Vijay in particular was always very I don't know what the word is, but very descriptive in informing us and doubting our rights under the joint venture agreement. At no point in this discussion did he come and say, yes, you have rights under this joint venture agreement, and this is what we're going to do. He would come into the meeting and say, the King and Spalding would say, we have rights under this joint venture agreement, and he would say something like, let's assume you have rights under this joint venture agreement. If we were to say, so there was always a question mark from the day we started the meeting with the governor, who said that this needs modification, all the way up till the very end. There was always a question mark about, from the DIFC side, they would not come and clearly state and accept our rights under the joint venture agreement. We had to inform them in every meeting, and they would shy away from it in every single meeting.
I didn't ask you about any of that, Mr. Hostin.
No, but the question requires history. So I'm giving you the history behind all of this.
No, the question was about the terms of the term sheet, and not about any of the reasons for why the terms of the term sheet came to be what they were. The question is whether you accept that the term sheet suggested terms which were different from and inconsistent with the terms of the JVA. Do you agree with that, or do you disagree with that?
I disagree.
All right, then we'll have to go through them. So if we go down to clause 4.
Mr. Montague-Smith, is there a lot of point in that? In the sense that I can read the documents for myself, I can see they're inconsistent.
I understand that. I hear what you say, my lord, and I'll move on from that.
It's a matter for you, but
No, I agree.
what this thinks about what the terms are compared one with the other is in one sense neither here nor there, unless there's some point to be made about his credibility.
Well, I think there is some point to be made about credibility, my lord, but I think we've probably got enough material to take it.
I'm sorry for interrupting, and you take your own course.
Well, my lord, I think I'll move forward.
Mr.
That's
Hosson,
not to say I'm abandoning, my lord, I'm sorry. That's not to say I'm abandoning some. Sorry.
I just want to say something to Mr. Hosson so he doesn't misunderstand what I've just said. I understand perfectly well what you're saying, Mr. Hosson, that in the context of negotiating a settlement, you put forward proposals, which it's up to the other side to accept or reject. And that's your essential point, isn't it?
Yes.
Yes. All right.
Mr. Hosson, let's move forward in the chronology a little bit, if we may, and we go forward to paragraph 24 of your statement, please.
I'm going to read it.
Yeah, please.
Go ahead.
Thank you. All right. So you refer to a meeting on the 4th of November 2015. Yes.
Correct.
And the purpose of that meeting was to discuss the term sheet. Is that right?
Correct.
All right. And do you recall at the meeting that there was a discussion about fixing the shareholding percentage of each of the parties?
The percentage, the discussion of the percentage was a discussion on ongoing discussions.
Do you recall that at the meeting that we're talking about on the 4th of November, there was that sort of discussion?
Right now, I don't recall, no.
That's fair. It's 7 years ago or 6.5 years ago. Is it fair to say then that your recollection of what happened at that meeting is not terribly clear?
If I can get access to the meeting details, it'll be clear. And for the most part, and then again, I'm repeating myself, I can state the facts that happened as they went. But the details of the meeting, who sat where and who wore what, no, I don't have a recollection. But I have a clear recollection of the course of the negotiations as they move forward.
Yes, all right. Can I show you what the DIFC's record at the time of the meeting was? And then I'll ask you whether that accords with what you remember. If you turn forward to page 2082.
Go ahead.
Do you see there? It's in fact a board paper, an update to the board of directors of DIFC Investments, and this document comes shortly afterwards. I believe it's dated 7th of December 2015, and you will not have seen this document, but just to show you, it is a record that was taken at the time by the DIFC, and see if it fits with what you remember. So it says paragraph 4, on the 4th of November 2015. A meeting was held with Hexagon's lawyers to discuss the way forward, and the latter expressed Hexagon's willingness to pursue the joint venture structure. So that is probably right, isn't it? That you expressed Hexagon's willingness to pursue the joint venture structure, yes?
In principle, I don't recall the specific, but our intention was always to proceed.
Yes, all right. And in the context of that, you'll see paragraph 5 then, the main point of discussion was whether the respective shareholdings in the joint venture company to be formed shall remain at 32.5%, 2.5% and 65% for DIFC, Nexus and Hexagon respectively, and then so forth, or whether the total built-up area and project mix should be reconsidered in the light of current market conditions and the relative shareholdings readjusted based on current land value and current construction costs, yes? So do you remember that?
What I remember is that in the discussion, the initial discussions of with the DIFC, the point of altering the percentage was presented to us starting with the governor, and it pursued throughout the conversation. And the point as to how these.
I'm afraid, Mr. Hosson, we've lost you.
I've lost him as well.
Yeah, can someone try and get him back? Have we lost Mr. Springe too?
No, I'm still here, and we've got.
You're frozen.
I'm frozen as well, am I?
Yeah. But
Mr. Hosson is back.
Mr. Hosson is back, yes. Mr. Springe, are you hearing us and audible?
I'm hearing you very clearly and seeing everybody, although Mr. Hosson was frozen for a moment. I don't know whether you can see or hear me, but
You're frozen on site, but we can hear you perfectly. So we'll continue if we may, but
probably best if I'm frozen.
You better go back to your question, Mr. Montague-Smith, because Mr. Hosson froze for, I'm not quite sure how long.
Go ahead. Can you repeat the question so that we're back in order?
Yeah, so I'll remind you where we are. We're dealing with the meeting on the 4th of November 2015. I showed you some notes about what was discussed there, and we were talking about whether it was right that the main point of discussion was the respective shareholdings in the joint venture company, yes? That's probably right, isn't it? That was discussed.
As I mentioned, the discussion of the percentage was prevalent in most of our meetings with the IFC.
Yes, and as we from the term sheet, one of the things that was proposed from your side was that the land valuation should be fixed at 100 dirhams per square foot, yes?
Again, this is a proposition.
Yes, that was the proposition, and the response that came back was that there should be a discussion, and it should be the shareholding should be fixed by reference to the existing land valuation, the current land value. Yes, do you remember that?
No, but what I can remember is that the discussion was not. It was more of a general context. Because they were settlement negotiation, we were negotiating everything as a whole. So the discussions were, what's the best use, what's the percentages, what are the steps that we need to go forward. So it wasn't a black and white discussion on percentages alone and whether land value would be market value today or not. So it was a global discussion. And then, but what was clear from it is when we started this discussion is that we had to revisit the composition of this Hexagon's plot development because of the master plan that had just been presented to us by the DIFC. So when there's a discussion of percentages, it wasn't or land value, it wasn't segregated as a discussion on its own. Everything was being discussed as one full package.
Yes, but the way in which the shareholding percentages were going to be determined is one of the things that was addressed in the term sheet, yes? As a proposal.
As a proposal.
Yes, but as a proposal, it was one of the things addressed in the term sheet, yes?
But even if it was addressed in the term sheet, in the negotiation, it was an ongoing discussion. So
Yes.
so if there's a certain concept that was put in the term sheet, the discussion wouldn't be only fixed based on this concept. The discussion would encompass other concepts. For example, if we were to say that the land value in the term sheet says that this is the way it would be valued, in the discussion it could be no, it's a fixed amount, or no, we would value it in a different way. So it wasn't. These are all proposals, and the discussion, as I mentioned earlier, were global.
Yes.
So,
all right.
But what was certain for us is the percentages in which we had under the joint venture agreement. Okay, what was being negotiated was up to all the parties. The IFC were proposing changes, we were proposing changes, and in the end of the day, this would culminate in a settlement agreement. So how we determined this was an ongoing discussion.
Thank you, Mr. Hosson. Mr. Hosson, you're sort of answering questions I'm not asking at this point, so I'm not sure we're very far apart on this. I think the only point I'm trying to make is that at this meeting, the proposals that your side had made about how to value each party's shareholding that had been made in the term sheets, those proposals were discussed during the course of this meeting, weren't they?
The term sheet that I just read and that you just showed me, it fixed at 100 dirhams per square foot. What you're referring to is that this method was going to be modified. The discussion of modification was amongst the things that we discussed, but the determination of the land value was not agreed upon in our discussions. So I repeat what I'm trying to say, which is basically all of these discussions that we were going and the propositions that we were making was part of an ongoing decision, ongoing discussion. So it wasn't a strict black and white proposal that, okay, if we discuss altering the land value or the percentage mix-up, it was part of a discussion. We were entertaining all the ideas, but I need to point out that we were entertaining all ideas in the hope of reaching a settlement agreement.
Mr. Hosson, I don't think there's any issue between you on this. You only have to look at the following paragraphs in this note to see that that's what it's saying. If you just read paragraph 5 and paragraph 6, I think that's simply enshrines exactly what you're saying. All these matters were discussed in the same context. I am saying that, but I'm saying because here there's also percentages as per the DIFC's minutes of meeting, and these percentages were not discussed on the onset of that meeting that we were talking about.
So is your evidence that you did not discuss specific shareholding percentages? Is that what you're saying?
I'm repeating what I'm saying. These percentages were discussed, but they were not. They were part of an ongoing discussion, and the determination of these percentages were part of an ongoing discussion.
We understand your position that these were all discussions. Nobody is suggesting that anything was agreed finally between the parties. So please, let's put that behind us and just talk about what was actually discussed. You accept that there was discussion of specific percentages for shareholdings. Do you also accept that the proposal that we saw in the term sheet, that the land value would be stuck at 100 dirhams per square foot, was rejected by the DIFC at this meeting?
Yes, it was rejected by the DIFC at that meeting.
All right. So you would accept that at the end of that meeting, you knew that the DIFC was not willing to proceed on the terms that you had suggested in the term sheet?
they were willing to proceed in the negotiations going forward. And this was one of the points that was being discussed. What I recall is that what we came out with in there is, first of all, we need to agree on the best use. So the issue of the percentage split came at a later phase. The real discussion of the percentage split came at a very later phase. Although it was talked about in the early stages was more about determining the best use and the way forward. And then the percentage distribution came towards the end.
All right. Is it right that you also discussed the question of whether or not the land could be used as security at that meeting?
Okay. The land that to be used as security was a discussion, and there was no clear, firm answer from the DIFC that it was not to be used. We proposed it. DIFC didn't, until a later phase, say that they didn't accept to do that. But for us, we were proceeding on a common understanding that we would mortgage the property. But to be honest with us, for us as Hexagon, this was irrelevant. This was a point of discussion. We proposed it in terms of in a business context, but for us, whether they approved it or they didn't approve it would not affect our funding capabilities. And moreover, it was not a prerequisite for our discussions going forward.
Yes, but the questions about what was discussed, you accept that it was discussed. And I'm going to suggest that at that meeting, the DIFC made clear that they rejected the proposal that the land could be used as security.
No, there was no clear rejection in that meeting that it could not be used as a security.
And the other issue was that the term sheet had suggested that the proceeds of sale of the property, off-plan sales, for example, could be used to offset the construction costs and simply reduce the amount of the investment that was needed by Hexagon. That was also something that was discussed at the meeting, wasn't it?
We discussed off-plan sales, yes.
And but you also discussed the use that could be made of the revenue generated by off-plan sales, yes?
We discussed, but in Dubai, there's a governing body which determines how you can use the proceeds of funds from pre-sales construction related to the project.
Well, the discussion that was being had was, as I said, your proposal was that the off-plan sales should be used simply to pay for the construction costs, yes?
I don't recall exactly what the proposal was, if it was directly for the construction cost or not, but we proposed off-sale plans, and I know that there's a regulating body that clearly states how you can use the off-sale plans in terms of for the construction of the project. And then I repeat myself in saying that this was a proposal we made.
I'm not asking you about regulations, and we know that you're very clear that these were proposals. But what I'm suggesting is that your proposal that off-plan sales revenue should be used to pay for construction costs without giving any credit, without adjustment of Hexagon's shareholding percentage, for example, that was also something that the DIFC rejected at the meeting, wasn't it?
I wouldn't say that they rejected it, because again, I'm saying that this was governed, there's a law regarding off-plan sales and how you can use it for the construction of the project.
Are you saying you discussed that law at the meeting?
We discussed that there is a regulation or a law that says how you can use the off-plan. So we were going to implement that. We were asking them to utilize that method for the construction of the project.
Yes, but what they were saying was that you can't just have that money go to pay for costs without that having some impact on the party's shareholdings, because otherwise Hexagon is getting something for nothing. That was the position that they took in the meeting, wasn't it?
No,
You don't recall that?
no. In the meeting, the discussion of the percentages only came at a later phase after we had done the studies, and in the meeting, we were discussing negotiating terms for the term sheet. So we proposed, I'm stuck again. We proposed certain elements to the term sheet, which we discussed. We did not go immediately from the term sheet into the negotiation of the percentage. It wasn't like, I will approve this one for you, and against this, we will ask for an increase in the percentage in the share. That wasn't the nature of the discussion.
I'm going to move forward to something else. If we go forward to paragraph 30 in your statement, please.
30.
30, yes. It's on page 75 of the bundle.
Okay.
Do you want to just read that and then I'll ask you some questions about it?
No problem. Okay.
All right. So starting with the meeting on the 16th of May 2016. Now you say that Governor Kazim told you that the term sheet was all in order, do you?
You're referring to paragraph number 30?
Yes. Well, I'm referring to the meeting on the 16th of May. You didn't give the governor a copy of the term sheet, did you?
No.
No. And as far as you're aware, you don't know that he'd ever seen that term sheet, do you?
I'm assuming that he had his legal department and he had his internally, they must have discussed it between each other.
Well, at this point on the 16th of May, the DIFC's position is that he hadn't actually seen a copy of the term sheet. So as far as you're aware, you've got nothing to say that that's right or wrong, have you? You don't know?
I don't know if he's seen the term sheet or not.
I see. But he wasn't saying we agree to the term sheet at that meeting, was he?
He was saying that everything is in order. I have to say that the conversation was in Arabic. Okay, so when I'm saying, I'm trying to do a little translation of what was being said into English, but what he said, that everything is in order, and that that they're finalizing the final needed point, and that we should be ready to go. And that at that point in time, what was being discussed was the term sheet between the DIFC legal department and King and Spalding and us. What we spoke about in the meeting was a general term.
So what he said at the meeting was that things were moving in the right direction, didn't he?
Yes, he did say that.
And that's what he meant. He didn't mean anything more than that. He didn't mean that anything had been specifically agreed.
We had two meetings with him. In the first meeting, he said that the percentage needed to be modified. In the second meeting, he said that we are in agreement. They're finalizing I need to translate it from Arabic to English, but basically he's saying that they're finalizing the points and that we're basically good to go and that we'll be signing imminently.
All right. Well, let's. Sorry. Carry on.
No, it's fine. We'll leave it to another point.
If we go to bundle J, tab 12, and go back to that letter we were looking at.
Would you allow me to take a bathroom break? I drank too much water in that small break that we had.
Sure, my lord will listen to your plea. Oh, I apologise, my lord. I didn't mean to give him permission. I do apologise.
No. I gave him permission, but I was on mute.
Oh, good. You can clearly lip read them.
Sorry about that.
All right, we were looking at page 117 again. J117?
Yes, I'm there.
You've frozen again, I'm afraid, Mr. Hosson. So if you just find your way to page 118 and hopefully you'll come back. Yes, you're back. Good.
118 or 117?
118, please. This is the letter
Okay.
we were looking at earlier. And again, we'll look at the passage that we looked at a little bit earlier, the second paragraph down. It was only recently, following Mr. Gaith Abu Al-Hosn meeting with you on the 15th and 16th of May 2016, that my legal representatives were invited to meet with Mr. Visser on the 18th of May 2016. In the event, and despite your assurances that things were moving in the right direction, this long-awaited meeting was extremely disappointing. So that was what was said at the meeting on the 16th of May. There was no suggestion that the term sheet was going to be agreed or even was close to being agreed, was there, at that meeting?
No, but these are two separate things. In the meeting with the governor, there was assurances that things were moving the right direction. After that, we started negotiating with Mr. Visser, which that was the disappointing point.
Yes, I'm just talking about what was or was not agreed at the meeting with the governor. But I think you've confirmed what I was suggesting. All right. Now, at the meeting with Mr. Visser on the 17th.
Can you repeat what you're confirming? Because I didn't.
No, I'm not asking a question, Mr. Hosson. The next question is.
Confirm something I said, sir.
Well, it's on the transcript, Mr. Hosson, so we'll move on. This isn't an interactive session. This is me asking you questions and you give answers. If I'm wrong about the answer that you've given, then your counsel will deal with that in due course. You're just here to answer questions, if you would. I wanted to move on and ask you about the 17th of May, 2016. The main issue at that meeting was, again, the issue of the percentage shareholding, wasn't it?
No, everything was being discussed all together. And the end of the day, what we're trying to reach to, in any methodology that DIFC wished to calculate their percentages, whether being the value of the land, being some formula they have, what we were interested in is the end result. So the methodology in which they will be using in order to calculate the percentages will only result in a final distribution of percentage. That final distribution of percentage will only be acceptable or not acceptable to us. So the discussions from day one on going through was not fixated only about percentages in the meeting. It was a global discussion, including the best use, including how we're going to develop the right. And in the most of the time in the meeting, there was general discussions that were where they would, for example, ask us about the existing shareholders, and they would make comments that about the existing shareholders, and that at one point in time we were told fraudulent, and another time they used different terminologies about the shareholders, and they questioned the shareholders. At other times we were told how important that piece of land is because it overlooks the Sheikh's palace, and that the Sheikh, while passing through the DIFC, wanted to make sure that this plot is built, and that they have the expo coming up in 2020. They wanted to make sure that we are committed to go forward and that we would build in time. And these discussions, we kept reassuring them that we're ready to go, we're ready to move, and we would discuss parts of the term sheet, we would discuss the best use of the land and the way going forward. So the meetings, we never had a sit down, a face-to-face meeting, which we said, I offer you 20, and we say, no, we want 25, and this is because this. We never, that was at a later stage, and that was when we finalized the best use, we finalized the feasibility studies, the IFC, and we agreed with the IFC on all the common points and the cost of construction. They went back and they came back to us and said, this is what we're offering. We went, we discussed it internally, and we came back and we accepted this offer. So how they came to this conclusion for us is really irrelevant, because in the end of the day, we were looking to, we have a joint venture agreement and what the end result would be.
Have you finished, Mr. Hodson?
Yes, I am.
All right. The question was what you were discussing at this particular meeting on the 17th of May. Now,
I told you.
One of the main points that you were discussing was the way the shareholding would be split between the two parties, yes? Just focus in on that question. Sorry?
I'm happy to repeat the same answer.
No, don't repeat the answer because it's not an answer to the question. The question is at this meeting. Why don't you want to answer this question, Mr. Hodson?
I answered it because there was no particular discussion about percentages in a meeting. It was a general discussion about almost everything related to this piece of plot of land and the JVA as amended.
Right, Mr. Hodson, can I ask you to look at paragraph 31 of your witness statement? Do you see there, you talk about the two meetings and you say, during those meetings, I took a brief handwritten note, the salient points from which I set out below. Yes. So one of the salient points was, firstly, changes, minor changes in ownership percentages. So you talked about the prospect of there being percentage changes to the percentages, yes?
This was what I said earlier in the meeting with the governor. He said that there would be minor changes to the percentages.
Yes, so you were talking about the way in which the shareholding would be split between the two companies, yes?
With the governor, we did not talk about the way it was going to be done. He just basically said that there would be minor changes to the percentage. We did not discuss the way that these percentage would be calculated.
All right, well then if you see at 31.4, Mr. Visser said that based on the back of an envelope calculation, Hexagon would be given the opportunity to buy into the project at a price of 300 dirhams per square foot. We asked why he had not factored in the 480 million dirhams Hexagon had already paid for the right to develop the plot. The DIFC replied that they had concerns about some of Hexagon's UBOs. We asked what these concerns were, and Mr. Visser replied that we would have to make their own investigations. Do you accept that when referring to the price of the land, Mr. Visser was talking about a means to calculate a percentage ownership interest split between the parties? Do you accept that?
Yeah, so this reconfirmed that what I was saying, that in the meeting, the discussion was general, and part of the discussion, Mr. Visser basically said, if we were to calculate, this is how we would do it. And he did a back of the envelope calculation, but it wasn't an ongoing discussion. It wasn't a proposal given to us. It was just part of the conversation.
Yeah, so you were discussing how to go about determining the shareholding split of the joint venture company, weren't you?
No,
All right, let's move on.
he just basically,
Bear with me. Now, I think you say at this meeting that Mr. Visser told you that the JVA was not binding. Mr. Visser's recollection is different. He says he did not ever say at this meeting that the JVA was not binding. Would you accept that as being true?
it's basically what I said earlier. He would insinuate by using terminologies that were carefully chosen that it is. So he'd say, let's assume you have, in the case that you did have. So he would always leave a question mark as to.
So he'd leave a question mark, but he would then say, on the assumption that you are correct, that there is a binding JVA, this is how we should move forward. Is that a fair summary, fair characterization of how he approached things?
He would say, he would make that statement, but it wasn't linked to how we would move forward.
Well, you said
Of the settlement agreement, the discussions of the settlement agreement were independent of the JVA as amended with the breach and the history of the project. So we were, again, I'm repeating myself, but I'm forced to do so. We were discussing everything as part of the settlement agreement.
yes, but you said that he said, let's assume that you have, and you didn't finish the sentence, but what you mean is let's assume that you have a joint rights under the joint venture agreement. So that's how he put it. That's what you're saying, yes?
This is a recollection. I can maybe
Yes.
not these exact words, but he would say, let's assume, or he'd say, in the case that, for example.
And he's saying, let's assume that for a particular purpose. And the purpose, he was saying, let's assume that, is so that you could discuss how to take the project forwards, yes?
No, the point that he would say that because King and Spalding were very firm to say that we have rights under the JVA as amended. And in order to progress the meeting, because each one had opposing position, we would say, let us assume, or he would give that sentence and we would move on to the discussions.
Now, this letter that we've been looking at page J117 and J118, that was a letter that was sent in June 2016, yes?
1 second. I don't see the date on the letter.
I think you said in your witness statement.
Maybe
Yeah, so if you look at paragraph 33 of your witness statement. Do you see that? Second line. Yes, so you don't really remember it. It's just that's, as you sit here today, you don't really have a recollection of that letter being sent. Is that right? Or when it was?
I don't have the exact the date it was exactly sent.
That's fair. Now, after that letter was sent, you did not actually follow up on that letter with Mr. Visser until he got back in touch with King and Spalding a year later. Is that right?
No, I followed up with Mr. Visser. I followed up with the Secretary of the Governor. I followed up with the Governor. I even went back and tried to follow up through Riemann Hashimi. I used every methodology in my capability to follow up on this letter.
All right, well, if we look at paragraph 33 of your statement, you describe sending the letter in the second line. You then complain that there was no official response to the letter or the term sheet, indeed, for over a year. and then you say various other things, and then the next thing you say is, finally, on the 12th of June 2017, Mr. Visser conveyed the possibility of an offer in an email to King and Spalding labelled as without prejudice. So you don't say in your evidence, at least, that there are any further communications between those two dates.
Because they were follow-up, they were not communications.
So are you telling us that there were no communications between June 2016 and June 2017?
What I'm saying is that in that period of time, my follow-up was based on telephone calls to the concerned parties that we have not received a reply to the term sheet. If there was any exchange between them, my recollection now, I don't recall.
If that had happened, you would have mentioned it in your witness statement, wouldn't you?
Which is what?
Why did you not write that down in your witness statement if you're telling us this now happened?
No particular reason, but because it was a one-way transaction. There was no feedback from the other end. So it was a high level follow-up from my end by trying to call particularly the secretary of the governor to talk to the governor to explain to him that we have not received the feedback on the term sheet. So it was.
But you didn't send any emails, for example, to Mr. Visser, and you didn't instruct King and Spalding to send any emails to Mr. Visser, did you?
The relationship, when it goes into the legal context, I'm not involved in the legal aspect. So when how the follow-up happens from a legal aspect between the legal team that wasn't my area of.
All right. In June 2017, Mr. Visser got back in touch with King and Spalding. Were you aware of that at the time?
Yes.
All right. And we see the email that he sent. It's in the same bundle J that we've just been looking at tab 13. And I just want to ask you about your response, your reaction to this letter. So you see this is an email. If you turn to page 120, 12th June 2017, you see Mr. Visser is emailing Mr. Jawad. So you were made aware of this email, you said, and do you recall seeing this one?
Please allow me to read it. Which page you're talking, 120?
Well, I'm talking about the email. I want to show you a particular passage of the email at the bottom of page 120, but the passages I want to show you are the ones on page 121.
Okay, please allow me to.
Please read it if you'd like to, yes. Right, so you've read that. No, okay.
I'm not finished.
That's fine. Take your time.
Okay, go ahead.
All right. So he's saying, we'd like to make you an offer to purchase the land. Do you want us to set that offer out in a letter, or do you want us to come back to you and continue this negotiation of a further agreement for the development of the land? Yes, that's what he's asking. Yes?
No, that's not what I made out of it. You're referring to page 120?
I'm referring to the entire email. In this email, he is saying that during the board discussion, the possibility was raised. Hold on, wait for the question then, if you don't understand it. He's saying in a board. I'm sorry, what?
You're referring he as Jawad Ali.
No, this is an email from Mr. Visser. Have you read the email, Mr. Hosson?
Yeah, that's why I'm asking you. This email, there's an email coming from Jawad.
Which email have you been reading, Mr. Hosson?
I started at page 119, and then I'm on page 120. Which
No,
one are you referring to? Page 21?
I asked you to read the email that starts in the middle of page 120, Mr. Hosson.
There's something wrong. Oh, here, the bottom part. This is the bottom part.
Do you need time to read that now?
Yeah, let me just read this, please.
Take your time, Mr. Hosson.
Okay.
All right. So in this email, Mr. Visser is suggesting two possible ways forward, isn't he? One is that he presents a proposal for the purchase of the land, and one is that he comes back and continues the negotiations that were going on before. Yes.
He presents his comments on the term sheets. Correct.
So there are these two alternatives, and then in the final paragraph, he says ultimately the latter, which means he says ultimately the latter will not change anything on the underlying JV and any rights and obligations the parties may have under the current JV agreement until the parties have agreed heads of terms to sell the property. But at least it will focus the parties' attention on what is the preferred option going forward. So when he refers to the underlying joint venture and a current joint venture agreement, when you saw this at the time, you must have seen that the defendants were proceeding on the basis that if the negotiations failed, then everyone would go back to their rights under the joint venture agreement. That must be what you understood at the time, right?
No, because what we didn't know at the time is that the IFC had sought external legal advice, and that external legal advice said that the JV is binding as amendment, and they seem to have pivoted in their discussions, but we did not know that. That was in the background. But throughout the time that we were in these discussions, the position remained the same. The first time that for me, as a person negotiating or the settlement agreement, the terminology partner came was in 2018 when I had the meeting with ICD Brookfield, and the terminology as partner came based on the new 70-30 split.
Can I ask you to look at paragraph 43 of your witness statement, please? Move through this. All right. Now, paragraph 43, you talk about a meeting between yourself and Mr. Al-Kindi, which took place on the 19th of September 2017. And I think you say you accept that Mr. Visser was at that meeting, yes?
Yes.
Do you remember that meeting?
Yes.
All right. Now, I think what you say is that you say KSA was stating that the JVA as amended was valid and binding, and Mr. Visser stating that it was not. Now, again, when you say Mr. Visser was stating that it was not, do you mean that he was using the sort of language that you've described previously, such as assuming that you have rights under the joint venture agreement? Is that what you mean?
Yes, that's what I mean.
So you're not saying that he came out and actually said the joint venture agreement is not binding?
I don't recall the statement being said in those clear terms.
All right. Now, obviously, Mr. Visser's recollection of this is different, and he says that he didn't give he didn't give or didn't intend to give the impression that he was questioning the validity of the joint venture agreement. Do you think that that could be fair?
No,
Right.
the impression was crystal clear.
But nevertheless, at this stage, it must have been crystal clear to you that the DIFC was proposing to allow Hexagon to develop the land if terms could be agreed, yes?
Hexagon would allow us to develop the land if the terms were to be agreed, correct?
I think you said Hexagon would allow, but I think you mean the DIFC would allow.
The FCS would allow us if the terms were to be agreed.
Now, in paragraph 44 of your statement, you mentioned seeing a report from Knight Frank, yes?
Correct.
And you say that it proposed a completely different design with a completely different mix of residential, hotel, retail, and office space. And you say that it covered the entirety of the DIFC, yes?
Correct.
And you say, according to the JVA, the project was to comprise approximately 40% offices. But in the Knight Frank report, this figure was increased to 80%. All right, can we have a quick look, please, at the Knight Frank report, which you will find in Bundle F, Volume 5. And if you could go forward, please, I think it's, is it tab 27? No. 277. 277, I believe. Do you have that? You see the Knight Frank report? Is that the Knight Frank report you're referring to? Yes.
Yes.
All right. And then if you turn forward in that document to page 2514.
Mm-hmm.
Oh, is that right? A bit better. So the project plot that we are dealing with is plot PA01, yes? That was the plot that was going to be developed by Hexagon, yes?
Correct.
And I'm sorry, I've taken you to the wrong document because that's not part of the report. In fact, the part that I wanted to show you was page 2243. My apologies. All right.
Okay.
That's the better one. So do you see there, there's that's the introduction to the report. It's actually the second page of the report, and it says, do you have it?
Yes, I
It
do.
says, we are pleased to submit our highest and best use study for the plots CB01 and PB01, along with entertainment and leisure recommendations for plots CP05 in fulfillment of our proposal. So actually, this report wasn't a highest and best use report for the whole of the DIFC, was it?
No, but this report was sent to us after the meeting.
Yes, it was sent to you after the meeting simply to assist you in preparing your own highest and best use report, wasn't it?
But in the meeting, Mr. Al-Kindi informed us that there was they brought Knight and Frank to reassess the master development of the DIFC as a whole, and he mentioned that the usage of plot PA01 had been modified, and he handed us that one single paper that you just showed by accident. He gave it to us physically, okay, which showed the increased usage of the office space. And then we requested the Knight and Frank report to be sent to us by email, and he sent this email as the Knight and Frank report. So what he told us in the meeting was that they did the Knight and Frank did the study for the whole of the DIFC, but what we received was this email, which was very particular to other plots. But this would also be relevant for whomever was doing the best use to know what the Knight and Frank opinion is for the usage of the DIFC.
All right. Let's go back to your witness statement. Break that down a little bit. What you say in your witness statement is Mr. Al-Kindi showed me a report prepared at the DIFC's request by Knight Frank and covering the entire DIFC, and then you exhibit the document that we've just seen. So can you accept at least that the Knight Frank report did not cover the entirety of the DIFC?
The Knight and Frank report that was sent to us by email does not cover. But when Mr. Kindi was talking, he was talking about the DIFC as a whole.
Mr. Al-Kindi did not say you have to follow the use mix in the Knight Frank report, did he?
No, he did not say that we have to use, but he did mention that this usage for this PA01 was based on the overall vision of the DIFC, and that it had been coordinating with all the local authorities, being the government, the utilities, the road transportation. So although we were not bound by that particular usage, we had some restrictions as to what the usage can be, because the fact that the development of the DIFC as a whole had moved forward, so we had to comply within the development as a whole.
But at this stage, the plan was for Hexagon to go off and get a report from Deloitte on the highest and best use for this property, yes?
It wasn't Hexagon, it was a joint decision between us and DIFC, so that we have a common ground to discuss, because the JVA as amended had proposed something. The new master plan of the DIFC envisioned something else. So in order for us to come to a common ground, we agreed that we want the best interest of both parties. So we went and appointed a third party to come and assess the best use for that property, independent of the parties themselves.
But Hexagon went off and appointed Deloitte, not the DIFC, yes?
Because somebody had to incur the cost. So we took it on our shoulder that we would appoint them because we incurred the cost.
Yes,
I think joint decision.
I think you're seeing disagreements where they don't exist, Mr. Hosson. My question was simply that the plan was that Hexagon would go off and get the report from Deloitte. So that's what happened. That was the plan, yes?
Hexagon went, but it was agreed by both parties that we would go.
All I'm asking you is what was agreed, and I think you accept that it was agreed. There's no need for all of this disagreement. You're seeing disagreement where there is.
We didn't take the decision on our own, sir.
I didn't suggest that you did. I didn't suggest that you did. So if you listen to the question and answer the question, then we'll move faster. All right. Now, let's move on to paragraph 45 of your statement. You say we knew the DIFC, do you have it? You said we knew that the DIFC thought that the project initially envisaged in 2004 to 2005 was not going to be commercially viable in 2014 to 2018, particularly after the impact of the global financial crisis had on the Dubai real estate markets. Now, as originally planned, by that you meant the size of the development and particularly the mixed use of the development, yes?
First, allow me to read the paragraph and then I'll answer. Okay,
Right.
can you repeat the question?
Yes. So when you are talking about the project as originally planned and that the DIFC did not consider that to be commercially viable, you are talking about the use mix and the size of the development. Is that right?
Correct.
Okay. All right. And you say that you did not necessarily agree entirely with the DIFC's assessment of the current market. Do you mean you did not necessarily agree that that mixed use and that project size needed to change?
Which mixed use are you referring to? The one in the Knight and Frank report or in the JVA as amended?
In the JVA as amended.
In the JVA as amended, there was more than one scenario. So the IFC came and said that this project is no longer viable, and the IFC's reasoning, I don't know what they are, but the landscape of the IFC had changed, and the uses of the DIFC also had changed, and the offerings that the IFC have in the market was also changing. So the IFC at one point in time had which it still does, I'm assuming, was planning to develop a lot of office spaces. So having a lot of office spaces wouldn't make sense anymore. Maybe it would be we needed to have more residential. So the IFC said the project was not viable. We were uncertain because our developers or our beneficial owners believed in the project and believed that whatever they were going to build on this particular piece of land was going to be of great success because of its location and the fact that it was in the DIFC. So in order to overcome this discussion, we agreed that we'd engage a third party to come and tell us what is the best mixed use. Not my opinion, not the IFC's opinion. Based on the current market condition, what's the best use for this piece of property?
All right. So when you say in your statement, we did not necessarily agree entirely with the DIFC's assessment, are you saying that you did not agree that, for example, having 40% offices was not commercially viable in 2014 to 2018? Is that what you mean there?
No, I don't really recall what I meant by that particular sentence. So I would rather leave it to say that I don't really recall what I meant by when I had written that sentence.
Well, let me ask it like this then. At this point in discussions, we're in 2017. Did you and Mr. Ramazan, as far as you're aware, agree or disagree that having a mixed use, as was set out in the JVA, was not commercially viable?
The mixed use itself, we were not certain whether it was viable or not viable. Although what we had envisioned is that the mixed use is viable because of the strategic location of this particular project.
So you had not formed a concluded view. Have you ever formed a concluded view as to whether the mixed use in the original JVA was viable or not viable?
We were under the belief that it was viable because we believed in this project and we believed in this plot of land.
Can I ask you to pick up bundle H, please?
I need to be clear what mixed use we're talking about.
So, all right, thank you, my lord. If you go back to your witness statement.
No, I mean when you refer to the original JVA.
Yes, I'm showing you what the witness has said about his understanding of the mixed use in the JVA.
All right.
And we'll work from that. So, Mr. Hosson, if you start at page D80, paragraph 44. Yes. Do you see there? It's starting with the final words of that paragraph. According to, do you see there? According to the JVA as amended, the project was to comprise approximately 40% offices. Yes, so that's your understanding of what the JVA required, yes?
Yes.
Yes, all right. And if we go to bundle J and we look at the JVA, we can see where that comes from, can't we? Bundle J, volume tab 1. That's the JVA, yes?
Yes. Which page are you looking at?
If we go to page 18, please. This is part of Schedule E, the project computations.
Page 18.
Yes, do you see that? And so under the heading all do you see all scenarios assumptions? Yes. And then built up area. And you can see the total built up area that was at that time being envisaged was 97,650 square meters. And then you see the offices provision. Do you see that about 5-6 bullet points down? 37,800. So this is where you've got your figure of 40% from for offices, yes?
Honestly, the figure that I got of the 40%, when I did my written statement, it was from a recollection in my mind. How that particular number came into my mind, I'm truthfully honest, I do not recall. But in my mind, this was the number. How it formulated in my mind, I'm not sure. Was it part of a discussion? Was it part of a document I read? Was it part of the discussions I had with the IFC? But it was it was a recollection in my mind, but I don't recollect how it came to be a recollection in my mind.
I see. But you do say that it comes from the JVA, yes?
Yes, that my recollection is that was the number from the JVA. But how I formulated that number, I'm truthfully saying I don't recall how that number came embedded in my head.
Are you aware of any other parts of the JVA that you might have relied on to formulate that view of the mixed use?
Can you repeat the question?
Are you aware of any other parts of the joint venture agreement that you might have relied on to come to that conclusion about the agreed mixed use?
No.
So it's most likely did come from these provisions, didn't it?
Again, I said I don't recall.
All right. But nevertheless, your view was that it was about 40% offices, and therefore if we continue looking at this provision, that would suggest furnished apartments of 8,400 square meters. Are you looking with me, please? Still J18, and residences of 14,000 and a boutique hotel of 14,000. So you've got 9%-ish for furnished apartments. You've got a mix of 14% for residences. You've got a mix of 14% for hotels. So that is, in your understanding, the proportionate mix, isn't it, that was provided for in the JVA, yes?
Yes, that was the mixed use as per the JVA.
All right. And then that is the one which you said, which you've given evidence about just now, the mixed use that was envisaged in those terms. You say your view was that you didn't necessarily agree that it was not viable. In other words, you thought it might have been viable, yes?
There's two components to whether being viable or not viable. There's the viability of the mixed use and the viability of implementing this cutting. Did you lose me?
No, I've got you.
Okay. So when we went into the discussion, and I'm repeating, but the principals believed in the project as a whole. So they were certain that, or they had a firm belief that whatever they were going to build on that piece of land was going to be a successful project because of its strategic location. So I'm not in a position to come and say, or at least that wasn't to come and say that this is viable or not viable. We believe the development as a development is a viable project. Now, what's the mixed use and how to agree on the mixed use? By 2014, there had to be amendments done because of the master plan of the DIFC. Everything had changed. So although we believe in the project as a project, the mixed use components might need to be changed based on the new givens of the DIFC. So when we engaged Deloitte to do the best use, we were trying to figure out what is the best use for today's for that for that piece of plot in today's event or in the grand scheme of the DIFC in Dubai.
Yes. So I think what you're saying is that you went to Deloitte for the best use and you wanted to develop a project with the best mix of use. But and then your evidence has been, but the original mix of use you think was could have been done if it had to be.
Okay, allow me to explain myself. When I'm negotiating for a settlement agreement. So everything that was prior to my involvement, whether it was viable or not viable, and this is all, for me, it was part of the history. I'm negotiating a settlement agreement today. When we're coming and discussing with the IFC, we went and came and said, what is the best use for the plot today? Because our intention is to develop this plot. If the existing mixed use is viable or not viable, or what the IFC and the Knight and Frank is viable or not viable, we need to come to a conclusion because we wanted to develop this plot. We didn't want to take assumptions based on Knight and Frank or the IFC or the existing, the given terms, and go ahead with the negotiations and then reach a point where we have to discuss the best use all over again and see which one is the best use. So we decided jointly, let's agree what's the best use of the project today. And that is what we did, and we came to a joint agreement of what's the best use today. Had we agreed on the terms and we had come to an agreement, we would have used the best use that we had agreed upon. So my just so that I'm clear, my involvement was very clear. My involvement was get to a settlement agreement. In which I failed to do, if I do not reach a settlement agreement, there's going to be a court case and there's a claim. So everything prior to my involvement is quite clear. My failure to reach a settlement agreement resulted in where we are today. So for our principles, it was clear. Either reach an agreement or go to court. Doing nothing was not one of the options for our beneficial owners. It was either reach an agreement, which is they wanted to do. They really tried their hardest and went an arm's length to try to reach an agreement after many, many, many years of negotiation and downfalls and everything. So we go back and we say, what was the agreed best use is what we told Deloitte to go and come and independently review and come back to us for what's the best use.
Mr. Hassan, that was a very long answer to not the question that I asked. What I'm going to suggest is that throughout your involvement, it was clear to you that as a result of the passage of time, there had to be changes to the agreement that had been struck in 2004 before the project could be commercially viable. Do you agree with that, or do you disagree with that?
I agree that there had to be changes to the joint venture agreement. I'm not in a position to say, or I was not in a position to say whether there had to be changes on the best use. Therefore, we brought an independent third party to come and tell us what's the best use and whether it was viable or not viable. We understood that in order for this to become an executable joint venture agreement, or that we can come to an agreement, a settlement agreement, we had to agree on the best use. So I'm not the one to determine whether it was viable or not viable. My involvement was to reach a settlement agreement, and amongst the steps to reach that settlement agreement was to agree on a mixed best use between the two parties.
Mr. Hosson, you said you agreed that there had to be changes to the joint venture agreement. That was a view that you shared with Mr. Romaizen and the other shareholders, isn't it?
My view is that we were reaching a settlement agreement. If the settlement agreement resulted in the modification of the joint venture agreement or a new agreement, that was a result of the discussions we were having.
But there had to be, you told me, changes in your view to the joint venture agreement. Yes? Was that view shared with Mr. Romaizen?
You're asking the same question, I'm answering the same answer. Anything that was to do with the legal aspects of how things developed and the existing joint venture agreement, that was not part of what I was involved in. I was involved in reaching a settlement agreement, and if that settlement agreement resulted in the modification of the joint venture agreement, that was one of the routes that would have been possibly we had to go down and do. So it was one of the options. Another option was to implement a new joint venture agreement. Another option was to put a framework. So all of the routes were available. At the end of the day, this was an ongoing discussion, and nothing would have been finalized until we all reached a settlement agreement. And this settlement agreement included the legal component, the commercial component, the usage component. All of them are integrated together.
Mr. Romaizen, can you pick up bundle H, please?
Mr. Hosson.
Sorry, I do apologise, Mr. Hosson. I'm losing my thread at this point. Mr. Hosson, please could you pick up bundle H?
I am.
Can you turn please to tab 19?
I'm on tab 19.
Tab 19? 18, I do apologise. Could you turn please to tab 18? Thank you. Thank you, everyone.
Okay.
This is your first witness statement, Mr. Hosson.
Correct.
We're just going to pause for a moment so everybody can catch up and find their place. Mr. Hosson, could you turn forward in tab 18, please, to page 295 of the bundle? And in the middle of paragraph 32, Mr. Hosson, you say this: it was clear that given the passage of time and changes in the Dubai real estate market, a new structure would have to be negotiated between the parties for the project to be economically feasible. Mr. Hosson, throughout your involvement in this project, that was your view, wasn't it?
My view was that we would need to reach a settlement agreement. So if you want to name the settlement agreement a new structure, that's fine.
Mr. Hosson, the question was not that. I'm not asking you about settlement agreements. I'm asking you about what would have happened if the parties had sought to proceed under the original terms of the joint venture agreement. And what I'm suggesting is that it was clear to you, and I'm only asking about your view throughout, it was clear to you throughout your involvement with the project that given the passage of time and changes in the Dubai real estate market, a new structure would have to be negotiated to make the project economically feasible. Do you agree with that, or do you disagree with that?
I agree that we need to put a new structure in place. The new structure is a component of everything. Mixed best use, commercial, legal. A structure is composed of many components. It's not just one component, which is the best use.
I see. So which components did you consider needed to change as a result of the changing market conditions in Dubai?
This is why we brought Deloitte on board to tell us what's the best use for today, for that period of time.
Deloitte only told you about the highest and best use. And until you received Deloitte's report, you wouldn't have been aware of whether or not they were suggesting that it needed to change from the joint venture agreement. So I'm asking you again, when you were involved in this project, which aspects of the structure did you consider needed to change in order to make the project economically feasible?
I'm repeating my question. I got involved in 2014.
You've given it, so would you like to withdraw the evidence that I've just referred you to?
Not at all. No, but I'm just trying to explain to you.
Bear with me. Can I ask you to turn forward in this document, please, to page 312?
Go ahead.
Do you see paragraph 78 there? And what I want to show you is the third line down. You say the DIFC itself knew it was impossible for the parties to make any meaningful progress on the strict basis of the JVA as amended, including for the following reasons. The economic circumstances and conditions in the real estate market had irrevocably changed by late 2018. Do you agree that it was impossible for the parties to make any meaningful progress on the strict basis of the JVA as amended?
I am certain we need the JVA as amended requires components to be agreed upon for it to become functional. And when we refer to here as the economic crisis and the changes, it's not only particularly for the mixed use, but also for specific component. For example, you can have a residential apartment, but rather than having a residential apartment of 500 square meters, you might have to reduce it to 30 square meters. The usability of the whole project as a whole, given the components given in the DIFC, would have to change. It's not only the mixed use in itself. We have to look at this as a whole. We cannot take out one component as alone. It had to be within the an overall view.
Mr. Hosson, I'm going to suggest that throughout your involvement with this project, you knew that the terms of the joint venture agreement that had been agreed in 2003 and then 2004 had to change. They had to change in ways that made them inconsistent and amended from the terms of the joint venture agreement. Do you agree with that or not?
I disagree.
My lord, I believe that we have reached the short adjournment, and that's a convenient time for me if it is for your lordship.
Yes. All right. So 3/4 of an hour's break at this point.
Thank you, my lord.
Very good, Mr. Hosson. We'll take a 3/4 hour break now, and same rules apply as before about not speaking to other people about the case. Thank you very much indeed.
Bye-bye.
Yes, whenever you're ready, please continue.
Thank you, my lord. Mr. Hosson, we had got to the stage where Hexagon was going to instruct Deloitte to look into the question of highest and best use. If you go to your witness statement, please, just so we can orient ourselves in the chronology. We're looking now at page D81 and paragraph 47. Yes.
D81, paragraph 47.
47, correct, yes. Did you see there you're referring to a conversation, a telephone call, and you say on the 6th of December 2017, Deloitte joined a meeting with the DIFC held by telephone to discuss the information that Deloitte needed in order to finalise its report. So that was the purpose of that call, was it?
Yeah, because the Deloitte needed information for it to develop or to come up with the best use.
I see. So at this point, they hadn't yet reached any conclusions about what the best use was.
I think by this point they had already formulated something, a basic understanding of the best use, but they needed more information from the DIFC to be able to finalize the study.
I see. So they hadn't reached any final conclusions yet by this point.
By December, no, by this point they hadn't come to a final conclusion, no.
All right. And so if we go to your witness statement in the other bundle, bundle H, and it's tab 18, I think.
Paragraph 18?
Tab 18, so we're looking at page 308, if you would.
Okay.
Paragraph 68. Do you see there, you say on the 6th of December 2017, Deloitte joined us at a further meeting with DIFC and set out their initial findings. Is it fair to say that they did not yet have any initial findings, and in fact, they were looking for further information at that stage?
That's what I just said before reading that. They had a general idea and they were looking for more information to finalize it.
All right. Now, you say in your other statement that Deloitte discussed the change in use in line with the Knight-Frank report. And I think you say that that was agreed in principle. But if they had not made any final conclusions about what was the best use, then it can't be right that there was an agreement in principle that any particular mix of use would be adopted, can it?
Yeah, well, see, there was a general understanding in the discussions based on the given Knight and Frank report, based on the Deloitte initial finding, and based on the given situation of Dubai at the time. There was an understanding as on the basic structure. Now, when we, in the discussions with the DIFC, when Deloitte were proposing the changes, there was the constraints which I already spoke about, which is the governmental constraints, which DIFC had already coordinated with other government entities prior to our discussions, which might have an effect on the best use. For example, the Road Transport Authority. So they wanted to make sure that the mixed best use, or the initial finding of the mixed best use, was actually applicable based on the different, based on the commercial, retail, and residential component, if it's in line with the RTA studies of that road based on the DIFC master plan.
Right, I'm just asking you about what was discussed at the meeting on the telephone on the 6th of December 2017. And can I put it like this? That there was no final agreement that the mixed use in any sort would be adopted for the project, was there? No final agreement to that effect.
Can you repeat the question?
On the 6th of December 2017, in the telephone meeting that you're talking about, there was no final agreement as to any particular mixed use, was there?
No, there was an initial finding, there was a general agreement, but Deloitte needed to finalize its report based on the givens. But there was an understanding or an acceptance from the IFC when Deloitte proposed to them, they were okay with it.
All right. Now you received the Deloitte report, I think you said paragraph 49. You say you received the Deloitte report on the 11th of January 2018. Mm-hmm. And we have a copy of that in bundle F. And if we go to tab 286, which you should find in volume 5.
Yeah.
It's tab 286, please. So you see there, that is a Deloitte report dated the 11th of January 2018.
Yes.
Yeah, so that's the report that you received on that date, yes?
That's the report they issued on that date, yes.
Well, they issued it to you, Hexagon, yes? Not, they didn't issue it to the DIFC. Now, there was a financial analysis set out in that report, wasn't there?
Yes, there is.
Now, you did not send this report, this version of this report, onto the DIFC at that time, did you?
No.
No. And if we go forward to tab 290,
Yes.
is it right that you, well, I'll show you the document in a moment, but firstly, is it right that you instructed Deloitte to remove the financial analysis of the report so that it could be sent on to the DIFC without that analysis in it?
Correct.
All right. And that's what Deloitte did. They removed the financial analysis and then you sent it on to the DIFC without any financial analysis.
Correct.
All right. And is it fair to say that the DIFC was frustrated by the fact that when the report was produced, there was no financial analysis in it?
Not at all.
Well, can you go forward to tab 296, please? It should be in the same volume. And in that tab, go forward to page 2821, please.
Okay.
And do you see there an email from Jacques Visser? Do you see about a third of the way down the page? And it's dated 27 February 2018. And it's sent to Jawad Ali, but you are copied on this email, yes?
Correct.
And you see what Mr. Visser says, as he says, it's been nearly 7 months since detailed offers were put to your client to move forward in this matter, both in respect of the terms of a proposed joint venture between the parties and the sale of plot PA1 to your client. All that we have seen in return is a high-level best use analysis, provided well past previously agreed deadlines, and which pretty much states the obvious in terms of development possibilities for the property concerned. There are certainly not any showstoppers in Deloitte's recommendations and mostly replicate the conclusions shared with you in the Knight Frank report provided to you in September last year. We certainly accepted more in terms of financial feasibility, as no realistic discussion on development options, joint venture terms or sale of land terms can be had between the parties without this. This also begs the question how your client came to the conclusion of pursuing the joint venture option without any detailed financial information at hand. So Mr. Visser is complaining that it's been 7 months and there's no financial analysis on which discussions can go forwards. So again, would you accept that the DIFC was frustrated by the fact that you failed to provide a financial analysis with the best use document?
It's very important that at this point in time, we realized that there was the legal team and there was the commercial team. The people or the team that was dealing with Deloitte and the negotiations with us at that point in time was the commercial team. And the commercial team had already their numbers and their assessment. So what they were looking for was the best use as per Deloitte's report. What they were doing internally, they were assessing their numbers, and they had calculated themselves the cost. And in the meeting, they would, in some of the meeting, or in at least one of the meeting, they actually shared with us their numbers. So for the IFC, our agreement with them was to find what's the best use for that property. Okay, and it was very clear from the IFC that they internally had their own team to assess and analyze the financials of it. And that's why in the history of Deloitte's report, we eventually share our financial finding, and they compare the two financial findings together, and they come out with a joint agreement, or we come to a joint agreement on the financials, which was then proposed as the basis for the joint venture agreement. So,
But this, sorry, go on.
So the initial for Deloitte, the initial task was to find the best use, and the commercial team of the IFC, which, by the way, in their own opinion, already know what's the best use for this property, because it's part of the Knight and Frank Master Development Plan. They know the numbers, they know what they can get in terms of return. They had a full vision as to what they wanted for that project. What we came and did, we said, okay, we're not going to sit and negotiate what I think and what you think. Let's get a third party to come to a general understanding. I don't know if you heard the second part of my answer, sir.
I did, and I've got a transcript as well, but thank you very much. I'm sorry, I was just checking something with my colleague. So the question was, as you understood it in February, it was clear that the DIFC was frustrated by the fact that you were not providing them with any financial analysis, yes? Would you agree with that at least? Now, you've given me an answer about why you think that isn't acceptable and why you think that might not have been reasonable. But from that email that I showed you, it must be clear that they were frustrated by the fact that you had not provided a financial analysis, yes?
No. And I insist to make a differentiation between the commercial team negotiating and the legal team that are writing the emails, because what we were progressing with the commercial team, things were very clear. We were moving in order, and everything was done within a grand scale of understanding, and everything was done jointly with the DIFC. We got in DIFC involved from the beginning with Deloitte every step of the way, so that we would win time rather than producing our own report and then presenting it to them. So it was a joint effort throughout the period, from day one until day zero.
But it's not a joint effort, is it? Because you obtained a financial analysis from Deloitte, which you didn't share with the DIFC.
Because DIFC's commercial team had their own analysis, and they had their own model, which they built their decisions on.
But they were clearly expecting a financial analysis to be produced from Deloitte, weren't they?
No. After this email, when they wrote it to us, we went ahead and produced the financial analysis. But in our negotiations and discussions with the DIFC, that wasn't the impression, or the DIFC commercial team, that wasn't the impression.
Well, if you go forward 2 pages to 2823, for example, you see that Mr. Visser says there in response to Mr. Ali, insofar as the Deloitte report is concerned, we note that there is no financial feasibility attached in relation to the different development scenarios suggested in the report. Is this something that is still being planned for, as they will greatly assist in any detailed discussions going forwards? So clearly at this point, Mr. Visser had understood that there was a plan to obtain a financial feasibility analysis from Deloitte alongside the highest and best use analysis, which would be shared between the parties.
At the later stage, they requested the financial report from Deloitte, and we shared it with them.
Well, you didn't share the full report with them, did you? You only shared some of the highlights.
No. The first report that we shared was to come up with the best use for that plot. And the IFC had in their own team, the commercial team, was going to build their own financial model based on the best use. Then, at a later phase in the discussion, Deloitte, the IFC requested the financials from Deloitte, which we eventually sent to them. And then after that point, there was a discussion between Deloitte and the IFC to come to a joint understanding on all the numbers and agree or to disagree on the numbers. Then they came to a joint understanding on the numbers, and it's based on that we got the proposition of the percentage split.
But the document which you actually sent them in March is the one that you'll find at tab 299. So if you go forward to that, please, you'll see what you actually sent them. Do you see at 2858, page 2858, you see a document dated 13 March 2008?
Yes.
That's the document you actually sent to the DIFC, isn't it? And if you go forward in that document, well, firstly, do you accept that that is the document that you sent to the DIFC?
I cannot confirm.
All right, well, we'll look into that then. And then if we go forward at 2864, there's a summary of key financial assessment input assumptions. In 2866, there's a summary of HBU scenario cash flows.
Okay.
So what you do not send is any of the detail of the financial analysis that was contained in the initial and the various different scenarios that were contained in the Deloitte report that you received. Yes?
Yeah, and I made clear that in January we agreed to send the highest best use, the HBU, for that piece of land, because the IFC had and wanted to do their own financial model based on the highest and best use.
We've just seen the discussions, the emails, where Mr. Visser clearly has understood that he is going to be receiving the financial analysis too. Wasn't that your understanding as well, that you were going to instruct Deloitte on an effectively, well, you said it was a joint instruction, and that the results of that instruction would be shared between the parties? Wasn't that the intention?
I will go again and tell you that there's a commercial team and the legal team. What the legal team was writing was not in line with what was happening with the commercial team, who was responsible from the DIFC side with Deloitte and with us to come up with the HBU.
Well, isn't it right that it was because you did not provide the Deloitte analysis that the DIFC then had to go away and do its own analysis and prepare its own models?
Not at all. The IFC had their own analysis and had their own model, and they modified it based on the HBU that was sent by Deloitte.
Can you go forward in the bundle, please, to page 2896? I'm afraid you're going to have to pick up volume 6. It should be the first document in volume 6. That's fine. And do you see there an email from Jack Visser to Mr. Jawad Ali, copy to Nabil Al-Kindi? Well, did you receive this email at the time?
Can I read it first?
Yes.
Okay.
So again, do you see what he's saying there? He's saying they've had to go away and get their own analysis done. And then he says, given the dearth of information on some of the key financial assumptions, this has taken some time to achieve. So do you not think at the least that had you provided more of the Deloitte analysis, it would have sped up this process of negotiation?
Not at all.
I see. Well, all right. Bear with me 1 second. I just need to check something, please. Sorry, I do apologise for that delay. Just one further thing on this. If you would go back, please, to bundle 5, volume 5 of that bundle, and pick up that email that we were looking at previously. I meant to show you one other thing in there. I think it's tab 296, thank you. And it's page 2821.
Which page?
2821, please. Do you remember, this is an email from Mr. Visser.
Okay.
So Mr. Visser emails on the 27th of February. This is the one where he says it's been 7 months and all you've provided is a highest and best use analysis. If you look at the 5th paragraph down, please, he says, all the above gives us the distinct impression that your client wishes to appear to be serious in its dealings with us. We suspect primarily for legal reasons, but in reality is playing for time. So you must have been aware at the time that the DIFC was concerned that you were simply giving the impression that you were trying to move this forward, but in reality you didn't have any intention to do so. So as to your understanding of the DIFC's position, were you aware of that?
This is why I made the differentiation when I first spoke between the commercial team and the legal team, because we were coordinating with the commercial team very closely on a I wouldn't say day to day, but very closely. And when we presented Deloitte, when we agreed to work with Deloitte, we worked with an open book strategy. We told them to go meet with the DIFC, collect information from the DIFC, share all the findings with all the parties, and we were progressing jointly together with the commercial team. In the background, and on another note, there was the legal team that was writing emails that does not really represent the actual fact that was happening on the ground. And this climaxes, this differentiation between the two, climaxes after the letter that was sent by the DIFC, where they sent us back to the JVA. And when I had a meeting with Mr. Al-Kindi, who said that we're still proceeding, there's no issues, we're about to move forward. So can you imagine what it was like for me to attend a meeting with the DIFC commercial team telling me we're still going forward, and having known that we received the letter from the legal team just the day before. He had no clue that that letter was sent. And he actually left the meeting. Please allow me to finish.
Well, Mr. Host,
he actually left the meeting because
Please let him finish his answer.
what's being written in the email, that was from the legal team. We were on the ground with the commercial team. He actually had to leave the meeting to go talk to the legal team to see if they actually had sent the letter, and came back and said, yeah, I apologize, I didn't know they had sent that letter. So we were coordinating with the commercial team, and this is being sent by the legal team. So that's why we have to split the tracks between what was being sent by the legal team and what we were doing with the commercial team on the ground.
Mr. Hostin, I want to ask you about something else. If we go to paragraph 51 of your witness statement, please. And you're talking about the discussions of the split in shareholding. And you say at paragraph 51.4, on the 19th of June 2018, Hexagon approved the 70-30 split. Do you see that?
Yes.
Now, in fact, when Hexagon responded in relation to the 70-30 split, they sought to impose conditions in relation to that agreement, didn't they?
Again, this was negotiations of a settlement agreement. The percentage on its own does not suffice. So if we agreed to a 70-30 split, it had to be agreed 70-30 split. What's the best use that was going to be developed? What's the framework of how we're going to move forward? Because you have to understand, at this point in time, Hexagon had been for more than 10 years trying to make progress, and every time there was a bottleneck which forbade them from making progress. So the last thing we wanted after this series of negotiation is getting into a bottleneck. So it was one complete settlement agreement that would assure the parties that things would move forward. And otherwise, there's the agreement, there's the breach, and there's the claim. So it was what was in front of us as either.
Yes, my point.
Reaching a full settlement agreement, or okay, go ahead.
You finished your answer. Thank you. All right. So when you say on the 19th of June 2018, my point is that when you say Hexagon approved the 70-30 split, in fact, Hexagon continued to negotiate in relation to that, didn't they?
We didn't negotiate on the percentage. We didn't negotiate on the percentage after that. We negotiated on. You want to write the rest of the answer, or is that sufficient for you?
No, please go on.
So again, we were negotiating one final settlement agreement. So once we've agreed on this 70-30 split, we were working on other aspects of the agreement.
So if you go to Bundle F, Volume 6, page 2981, please. Tab 308.
Page 2891.
2981, please. It's tab. If you've got the tabs, it's tab number 308.
I'm on the page.
Oh, good. Thank you. All right. So this is the email that you refer to in your statement as approving, Hexagon approving the 70-30 split. My point was, in fact, that this was a continuation of negotiation, because what Mr. Ali said is, as discussed last week, our client is prepared to increase the DIFC ownership percentage in the proposed joint venture to 30% on the understanding that, and then he imposes two conditions to his agreement to 70-30, doesn't he? So this is even a continuation of the negotiation of the 70-30, isn't it?
No, these are terms, as I mentioned, one settlement agreement. So we are agreeing on the 70-30. There's other components that need to be agreed upon. It's not just one item. It needs to be more than one item. And then again, I repeat my what I was saying. This is a negotiation phase. We can request whatever we think is good for us for the development. The DIFC have the right to accept or refute it.
One of the conditions that Mr. Ali proposed, do you see little Roman numeral 2, is that the DIFC agrees to reduce the value of the land to accommodate the current market situation and help achieve an acceptable overall return for both shareholders of the JV. So Mr. Ali is saying we will agree to a 70-30 split, but we want the DIFC to reduce the value of the land. Yes? You see that?
That's the literal context of the email.
Yes. And so the relevance of the value of the land is that, at least under the original joint venture arrangement, the idea was that the value of the land, however that was fixed, would be compared to the cost of the project, and that would determine the shareholding. That's the relevance of the value of the land, isn't it? That it goes into the question of who gets what in terms of shareholding. But
let me ask. Here, the shareholdings are in this email. The shareholdings already agreed, and we're asking to reduce the land. So how are you saying, we're not saying that the percentages are going to change if you reduce the value of the land. We're saying we accept this, but we're asking to change the value of the land for the returns. And in any case, I'll repeat, this is all part of negotiations of a settlement agreement. Had the IFC come back with a counter offer, we might have looked at it and accepted or not accepted it. And these are negotiations.
Just sticking with the question of the valuation of the land, no cash was going to change hands for the land, was it?
The land would be put in the joint venture company against the cost of the building. Correct.
No cash was going to change hands for the land, was it?
No.
So the DIFC was going to receive shares in the joint venture company in exchange for the land, yes?
Correct.
And its shares under the original arrangement were to be determined in part by reference to the value of the land, yes?
No.
Under the original joint venture agreement, you disagree with that?
Under the original joint venture agreement is something that was agreed upon and is history, and the percentages are stated and agreed upon. Today we are renegotiating in new terms, in a new environment, in a new stock. There's a lot of things that are being negotiated. The relevance in the end is what we come to an agreement as a whole. When we were negotiating, we were not negotiating on the basis of the land value versus the cost of construction. Had we been negotiating on that basis, then we would be looking at the cost of construction at the same time to see what was the cost of the construction and what was the specifications for the cost of the construction. What was really being negotiated is one general settlement agreement.
But you did look at the cost of construction, didn't you, in obtaining the Deloitte analysis?
Because the IFC had a very specific opinion about the cost of construction. So my intention was to make sure that the Deloitte cost of construction and that the IFC cost of construction are aligned. Because at one point in time, they were not aligned. They were not agreeing on the cost of construction.
But given that no cash was going to change hands for the land, there was no point in talking about the valuation of the land unless that was going to have an impact on the shareholding that was going to be given to the DIFC at the end of the project. Isn't that right?
Can you repeat your question?
Given that no cash was going to change hands for the land, there was no point in talking about the valuation of the land unless that was going to have an impact on the shareholding.
To be honest with you, I don't know where this point in the email came from. I do not recall where it came from, but I can assure you that what I'm sure of is that when in our discussion, there was no relevance to the concept of what's the value of the land versus, at least from our side. We were looking at it as one settlement agreement, and in the end of the day, what we were trying to reach is a settlement agreement which is very clear and with a way to go forward.
All right, and you never did reach a concluded settlement agreement, did you?
Well, if you're talking with what we were negotiating with the commercial team, we were under the impression that we were on the verge of signing imminently within a few days. And what ended up happening is a total turnaround by DFC in the last minute by sending us a letter, ignoring all of this time and money we spent to work on a joint venture, to work on a settlement agreement, to work on the percentages, to work on the best use, and come and say, go back to the original joint venture agreement.
You never had.
That's why we never reached it.
Yes, so the answer is yes, you never reached a concluded agreement, yes? I'm not asking you why, I'm just asking you to confirm that fact.
We never reached a final settlement agreement.
Right. And there was no agreement, for example. No, I'll leave it there. Now, at paragraph 54 of your statement, you refer to the new JVA framework Now, it's fair to say that all of that was still under negotiation, wasn't it? All of the terms of a future deal were under negotiation at this time, yes?
Correct.
All right, so there was, all right. And then you say you were feeling cautiously optimistic that the DIFC were genuine in their actions this time round. So, at this stage, you must have been relatively confident that the project was going to go forward, yes?
Again, based on my relationship and based on my exchange with the DIFC commercial team, yes, that was my position at that time.
But also based on your discussions between yourselves, you knew, but that by this point, the DIFC was accepting the validity of the original joint venture agreement, didn't you?
No.
Can I ask you to look at tab 319, please? It should be again in the final bundle of volume F, which is volume 6. Tab 319. And if you go forward in tab 319 to page 3033. Now, do you see there at the bottom of the page an email from Mr. Jawad Ali, dated 9 August 2018? Do you have that?
Yes. Yes.
And there's an email, it's sent to Mr. Williamson. Mr. Williamson is the Deloitte expert who is giving evidence in these proceedings, but was also the person who was running the financial analysis at Deloitte for Hexagon, yes?
Correct.
And it's also sent to you.
Yes, it had.
All right. And the email says over the page on 3034, Dear Robin, thank you for your prompt response and action. What we are looking for is an evaluation of Hexagon's 70% interest in the proposed joint venture with the DIFC. Now, I'll come back to this in a moment, but this is in the course of discussions with ICD Brookfield. Do you remember that?
I don't remember so can somebody just give me the date of the ICD Brookfield meeting so that I can...
I'll come back to the ICD Brookfield meeting. If you're not sure about that, we'll come back. But that's not the question at the moment.
I can't answer if this was during, I can't answer if this was during the ICD Brookfield meeting period or not.
All right. You don't know. You can't remember. That's fair. All right. We'll carry on in reading the email, please. Do you see this? What we are looking for is an evaluation of Hexagon's 70% interest in the proposed JV with the DIFC, meaning now that the DIFC has recognized the Hexagon development agreement and agreed a 70-30 JV, we need Deloitte to figure out the consideration Hexagon should ask a third-party purchaser. And we'll come on to that in a moment. So do you see there, Mr. Ali is saying that the DIFC has recognized the Hexagon development agreement? Yes?
Okay.
When he's talking...
Can I read the rest of the statement, please?
If you need to. You feel you need to read the rest of the email? All right, carry on then,
yes,
please.
Okay.
All right. So when Mr. Ali refers to the Hexagon development agreement, he is referring to the 2003-2004 joint venture agreement there, isn't he?
Can you repeat the question?
You received this email in August 2018. When you received
Correct.
this email, you must have read it, yes?
I read it.
All right. And you saw in this particular sentence, Mr. Ali was referring to the Hexagon Development Agreement, yes?
Yes.
And there was only one agreement by which Hexagon had the rights to development, yes?
No. Here in this email, there's two different concepts, if you read it correctly. The first one is Hexagon Development agreed on a 70-30 JV. So basically what was being discussed is basically the new settlement agreement. And then here, if you continue to read, third purchaser introduced by DIFC to take over its right under the original development agreement, taking into consideration the newly agreed ownership percentage and the development scheme. So they were buying us out of our right to develop this plot of land, but we were asking for them to do the valuation based on the given terms that we were in discussion about currently, because we had understood that we had agreed on the percentages and the way forward. So at this point in time in this email, we were actually looking ahead and not looking back. We thought we were going forward, and we went into this negotiations with ICD Brookfield with a positive attitude, although that was the first thing that, despite all the discussions and everything that we agreed upon, I get a call in the middle of the summer. I was not in Dubai, I was in Los Angeles, that said, and Nabil Al-Kendi said, we have a meeting with ICD Brookfield within the next 2 days, and they have an offer to buy your right to develop that plot of land. I flew for over 48 hours from Los Angeles to Dubai, just not to waste time, just to make sure things are going forward, to attend that meeting, and then go back. So what we have here is that they're buying our rights to develop the plot of land, which is PA01.
Yes, so there was one agreement, wasn't there, between Hexagon and the DIFC. There was only ever one contract, wasn't there? And it was the 2004 agreement, yes?
Correct.
And that was an agreement for the development of the plot by Hexagon, yes?
Correct.
So when Mr. Ali refers in this email to the Hexagon Development Agreement, he must be referring to the 2004-2003 joint venture agreement, yes?
He was referencing to that agreement, but he's also referencing in the same email the terms that we were negotiating at that point in time. So again, this is part of a settlement agreement. When you were discussing a settlement agreement, it's a mix of both worlds. It's not, you cannot isolate the two independently.
Yes, I'm not suggesting that you should isolate the two for all purposes, but I'm just trying to understand what you understood when you received this email. And so one of the things that he said in this email is that the DIFC has recognized the Hexagon Development Agreement. So what I'm suggesting is that you knew, and Mr. Ali knew, that the DIFC were recognizing the validity of the 2003-2004 joint venture agreement. That is what he's saying, isn't it?
No, because what we assume that, and we wrote that based on the assumption because of the way the negotiations were progressing. We were never told by DIFC at any point in time that they honored it. On the contrary, they kept trying to leave question marks about it. So I'm not entitled to say, but this is coming from a legal person. He knows what he's writing and what it is that he means by this when he's writing it. My understanding, if that's what you're asking me, my understanding is basically that we have the joint venture agreement and which was breached, and that we were negotiating settlement agreement. The IFC, we reached an advanced stage with them where we thought that we were progressing, and we thought that we had come to an understanding, and that they wanted somebody to come buy us out of our right to develop that plot of land based on our understanding.
Thank you. All right. And if you can go forward in the bundle, please, to tab 321. And if you go forward in that tab, please, to page 3048. Do you see there an email in the middle of the page from yourself?
Correct.
And you sending an email to Mr. Nabil Al-Kindi, and this is on the 29th of August 2018. So this
Correct.
comes a little bit, but not long time, after the email that we've just been looking at, yes? And I'm just going to read out a passage of this, and then we'll look at the response. You say, "Good evening, I hope this email finds you well, and that you had blessed Adha holidays." And then you say this: "After following up with ICD Brookfield, please find below the email received this afternoon, which is somehow conflicting and confusing. Kindly please let me have your input on the situation, and more importantly, your recommendation on the subsequent steps with IDC. It is important to note that Jawad and Jacques have given the negotiation period with IDC a target end date, which happens to be the 3rd of September. So if I can summarize it like this, and we don't need to go into details, but would it be fair to say that this is during the course of the ICD negotiations? Yes?
Yes.
And you're unhappy with the response from ICD. We'll come on to that in detail, but in broad terms, that's a fair description, yes?
Correct.
And so you approach Mr. Nabil Al-Kindi to ask for clarification about where this is all going.
Correct.
All right. And then if we look at his response on the previous page, 3047, do you see that?
Mm.
He says, "Dear Gaith," and then pleasantries. "I read the comments from ICD Brookfield. Maybe they don't see the project valuable to them within that price range. I'll talk to the guys and find out more." So that's he's coming back to you saying, "I'll see if I can find out what they're thinking." But then the next bit is the bit that I wanted to show you. "But as mentioned earlier in a couple of occasions, this attempt was a trial one to assist you and make a deal of it. If it works, great. If not, we are still under the current contract where we need to go ahead with this project." Now, the current contract he refers to, there was only one contract between Hexagon and the DIFC, wasn't there?
Again, there was one contract that was signed, but what's being referred to here as a contract is the... I'm sorry, when I'm pausing because my screen is freezing, so I'm pausing.
Nice. Tell me when it's
so what was being referred to here is basically the terms that we had come to an agreement with on verbally, or the understanding that agreement that we had come verbally. So what was meant by Nabil is that we need to finish this part of the agreement and proceed in developing this project land based on the 70-30 split, based on the Deloitte best use report. And if just to give some insight to this period of time, when we started the negotiations with ICD Brookfield, and to win time, because we were not very hopeful about this negotiation because we found it very haphazard. But anyways, we split the tracks. The legal team had to continue working on finalizing the agreement while we negotiated on the commercial terms. If we managed to secure a good commercial deal, then there's no need for the agreements to be signed. But if we failed, so that we don't waste time, we had that go in parallel right along the discussions with ICD Brookfield. So what Nabil is referring to here is go back and finish what you are doing with what the legal team is doing with Jack and the DIFC legal team.
The negotiations which you were dealing with did not lead to a contract which imposed any obligations on the parties, did it? Did they?
What negotiations are you talking about? The ones with ICD Brookfield?
No, the negotiations that you were having with the DIFC, they never led to any contracts that resulted in obligations on either party, did they?
No, but we were by that time in August, we were at a very advanced stage. There was no signed agreement. And if I refer you, I don't know where it is in the documentation, but when I finished the ICD Brookfield meeting, I wrote back to, I don't know, maybe Jawad, but basically it was the first time that we were agreed to as a partner and a 70-30 split. So in our understanding in the DIFC, that DIFC mentally or they have accepted that we are their partners based on the new split, based on the approval they got from the board meeting, based on the agreed best use that we came, all of us, to an agreement on. So commercially for me, we had agreed on the terms. What was left is the legal aspect of finalizing the terms to come to the settlement agreement, which we were in discussions.
But there was no sense in which those discussions led to either party needing to go ahead with the project. In other words, if all that had been existing were those negotiations, if there had never been a joint venture agreement, it could not be said to be the case that either party needed to go ahead with the project, could it?
I did not understand your question. You may repeat it.
The negotiations themselves did not lead to any need for the parties to go forward with the project because they weren't concluded.
They weren't concluded because of the letter that the IFC sent, which negated all the negotiations that we were doing and what we had come to the commercial agreement with the commercial team of the IFC.
All right. Well, what I'm going to suggest to you, Mr. Hosson, is that it must have been obvious to you that what Mr. Al-Kindi was referring to here was the JVA agreement, and he was saying if you can't agree something else, we'll have to go back to the terms of the JVA.
Not at all. What was being discussed here is based on the commercial terms that him and I had come and discussed.
Now, if we go back one tab, do you see they're starting on 3041?
Yes.
This is the Deloitte response to the request to, in effect, value the interest under the joint venture agreement, albeit with a 70-30 split, yes?
Yes.
All right. And the results of that valuation you see on page 3046.
Yes.
Did you see those at the time?
Yes.
And these were the evaluations that you obtained from Deloitte so that you could use them in your negotiations with ICD Brookfield, yes?
As part of the negotiations.
Well, I don't think you ever proposed to present these figures to ICD Brookfield, but you prepared, or you asked Deloitte to prepare these figures so that you would be able to decide how to negotiate a price for your interests, yes?
We did this so that we have a general direction of what it was at the time.
Yes, so you're effectively asking them to help you to value the interests that Hexagon held, yes?
Correct.
All right, and what they do is they produce a range of results depending on various different inputs and various different discount rates and so forth. And then they get to, I think on page 3046, a range of outcomes for the value that can be attributed, yes?
Yes.
We have had a look at these figures, and if you take a midpoint in the range of values, would you accept that it comes out at something like just under 100 million dirham?
This is based on the net present value. This is what the project as a project is worth. But this doesn't take into consideration the history of and our rights that we had throughout this period of time. So this was, if somebody was coming on a clean plate, this is what they would value the project based on a net present value. But you have to understand that our investors are more, they envision this as a strategic investment, and they believe that this project would do a lot better, and they believed in Dubai, the IFC, they believed in Dubai, and they believe that they truly believe that when this project, based on their knowledge of the land, based on their knowledge of the GCC, based on their knowledge of the history of the economic cycles going up and down, they believed that building this project was going to get them profits and that it was going to be a very successful project. So yes, this is Deloitte's understanding based on net present value and based on the market situation, but that does not reflect the opinion of the shareholders.
I see, but this, you said, I think, reflected the value of the project or the value of the contractual rights to somebody new to the situation. Yes?
Yeah, if somebody was coming new and they wanted to develop the project, these are the numbers that presented by Deloitte. This is what it is.
Yes. And so, as I say, would you accept that the midpoint of these figures is something around 100 million dirham?
We are stating facts from a report, yes.
Yes, all right. And so if somebody was to come to the project new and offer 100 million dirham, that would be a reasonable offer from their perspective, wouldn't it?
No, because the person, the entity proposing the offer, okay, is an entity which is very close to DIFC, and this offer that was pushed to us was just an offer that wanted, and so that we can go away. It was basically a go away offer. It wasn't a reasonable offer, and when this offer was made, on what basis was it made? ICD Brookfield didn't even study the project at that time. They just came in with a number. Why did they come with that number? Because probably, I don't want to make an assumption, but the IFC had told them a number, and they came and presented this number to us so that we can go away. And we, as Hexagon, we really wanted to develop this project. We were not interested in selling our rights under this project, but because the IFC came and pushed it forward, we entertained the idea. We wanted to develop the project. This is what the IFC is not understanding. We want to develop this project. Our ultimate beneficiary owners wanted to develop this plot of land. PA01 to them is the jewel of the IFC, the jewel of Dubai, and they wanted to develop it.
ICD Brookfield made you an offer of 120 million dirham, didn't it?
It made an initial offer of 120 million, and then they said they would go study and come back with a counter offer. That's why we waited for them to come back.
ICD made you the offer, though, of 120 million dirham, didn't it?
ICD did the offer in the presence of the IFC, and when they came and they presented this offer, they had not done any studies pertaining to PA01 nor its best use. And Nabil asked me if I can share with them the Deloitte report so that they can go back and do an assessment, and that's exactly what we did.
They had a project at the time in the DIFC, didn't they?
They had a project in the DIFC, correct.
That's a project that's now completed, isn't it?
Sorry?
That's a project that's now completed, isn't it?
Correct.
And I believe that is the most recent development in the DIFC.
Correct.
So they
the
would
Gate
have
Avenue. I think the Gate Avenue is more recent.
in terms of buildings.
Probably yes.
So they would have been well placed to understand the economics of constructing a building in the DIFC.
Yes, but they didn't have the particulars. They asked me for the particulars.
Is it not possible that the reason ICD Brookfield came in and made an offer of 120 million dirhams is because that's what they thought it was worth?
No, because again, I'm repeating what I'm saying. ICD Brookfield came into that meeting unprepared. They didn't have much details. We provided them with the details afterward, and that's why they wanted to go back and study and come back with an offer. And I'm not sure at what phase or what point in time, but we later understood that there was some sort of understanding, or DIFC somehow asked ICD to put an offer. I don't know, legally I don't know how that works, but all I'm telling you is in that meeting, ICD came completely unprepared, unaware, threw a number and asked us for the information. We provided them with the information, and after providing with them the information, they said they would go study and then come back to us.
In fact, the offer from ICD was an independent offer, and you are simply making assumptions about and drawing speculation about the relationship between ICD and the DIFC, aren't you?
I don't know if it's speculation or what, but I can tell you that this offer on the table was not a serious offer, and it was an offer to make us just go away. This is the reality of the fact. DIFC came, ICD Brookfield came to the meeting with no information in hand. They couldn't even discuss the details because they hadn't looked at it.
If another developer had come to you, who you accepted was completely independent of the DIFC, and had offered you 120 million dirham for this, then would you have viewed that differently? Would you have said, well, that is higher than the mid-range of values that Deloitte has told us to expect, so therefore this is a serious offer?
We were not entertaining offers. We wanted to develop the land. Our beneficial owners wanted to develop this project.
You were entertaining offers. You were talking to ICD Brookfield about selling your interest in the project to them, weren't you? So you were entertaining offers.
Based on DIFC's request.
No, DIFC asked you, are you interested in discussing this with ICD Brookfield? And Hexagon's response was, yes, we will have those discussions.
Nabil Al-Kindi spoke to me about this particularly, and he said, you know what, something new came up, and we think we have an interested buyer. I would ask that you sit with them and listen to what they have to say. And I said, yes, I would do that. And I flew across for 48 hours, 32 hours of flight between those 48 hours, so that I don't waste time and sit with them. I came to attend a meeting where there was nobody that was prepared, a number was thrown, nobody could defend it, and then when I presented what I had to present, they said, okay, let us study it and we'll come back later.
So is your evidence that you went into those discussions with an attitude that you were not entertaining any offers?
The IFC requested from us to go and listen to what ICD Brookfield had to offer. Okay, by that time, after so much time being spent on trying to achieve a settlement agreement, the last thing we wanted was a deviation. We wanted to get to a settlement agreement, and we wanted to develop this plot of land. This was our position at the time. In the midst of all of this, I get a call from the IFC asking me to please sit with ICD Brookfield and see what they have to say. If Nabil didn't make that call, we would have proceeded. And even with that call that he made, we accepted on the condition that we would double track this. We would see ICD Brookfield, but at the same time, we move in parallel to reach a settlement agreement, because in our intention was to reach the settlement agreement and develop this plot of land.
So do I understand it from you that in order for there to be any kind of agreement with ICD Brookfield, you would have had to see an offer which reflected the money that had been paid by the shareholders to purchase their shares in Hexagon?
No, and then that was you asked me this from before, and my position on this is clear. The shareholders.
I'm listening.
So the shareholders wanted to develop this project, and that was their intention, first and last. Basically, they wanted to develop this project. So anything that was being presented, or the numbers that, and just to make things clear, in all of the Deloitte reports, okay, nothing was ever included related to the amount that was paid by Hexagon to develop this project. So we were beyond that point, and we are trying to negotiate a settlement agreement to develop this part of land.
My lord, I think we're due a break for the stenographer, if now's a convenient moment.
Yes, let's take 10 minutes now. Thank you very much.
We're all present and correct, my lord.
Please carry on.
Thank you. All right, so after the ICD talks broke down, Mr. Hosson, Hexagon then provided proposed a new term sheet to the DIFC, didn't it?
Yes.
And we don't need to go through it, but would you accept that that term sheet, proposed, didn't enforce, didn't require, but proposed terms, which were different from the terms of the joint venture agreement?
Again, this is part of a settlement agreement. We propose terms, we discuss it with them, and then we come to see what we agree and disagree about.
All right, and then let's look at it. Then you received this letter on the 10th of October 2018. Now, some of the parties at least have been calling this the performance letter, but shall we call it the October letter? And if you go to bundle J, tab 22, you'll see it. Now, what I'm interested in is what you understood when you received this. I think you say in your evidence, don't you, that this letter was a volte-face. Is that language, an expression that you would use in everyday life?
Well, it was an expression that I used in my evidence statement.
Is that an expression that you came up with or that somebody else came up with?
I was definitely assisted, but this is my own expression.
I see. All right. And if we look at the letter was addressed to Nexus, but it was copied to Hexagon at the time, wasn't it?
Correct.
And you received it, I think, on the 10th of October, didn't you?
That's the date on this document in front of me, yes.
All right. You don't remember when you received it?
And I remember it was around that time, but the exact date I don't remember.
Understood. All right. And it refers, doesn't it, to an agreement? Do you see that under the heading? It says we refer to the above agreement, yes? And it refers to the joint venture agreement dated 14th December 2003. So that's the JVA that we've been discussing, yes?
Correct.
And it says a number of things. If you go down to the next paragraph, it says we write to give you notice pursuant to clause 9 of the agreement that DIFCA has assigned the land to an affiliated entity. And it refers to, in particular, referring to clause 9 of the agreement, that is DIFCA exercising a right under that agreement, isn't it? Yes.
These are legal. These are legal terms.
But wasn't it clear to you from that the DIFC was saying that the agreement was binding?
When we received this letter, first of all, we had been negotiating with DIFC throughout this long period of time, and we had reached certain common understanding with the DIFC throughout this period. And we were at the climax of about to reach a final settlement agreement. And then without anybody calling us, without anybody negotiating with us, without anybody informing us, okay? And one thing I must add, before we received this letter, I had already contacted Nabil Al-Kindi and agreed on a meeting some days later to see how we're gonna go about and finalizing the settlement agreement so that we can start on the development of the project. After my telephone, I'm frozen. After my agreement on the scheduled meeting with Nabil Al-Kindi, we received this letter. So not only had we been in discussions, not only had we had a very direct and open means of communication, nobody informed us of anything. We get this letter which negates and removes everything that we had been talking about. And it is addressed to Nexus, which they informed us that we should, and this is my understanding, I'm not talking in the legal term, this is my understanding of the letter. They, in the discussions, they were told us that we were, or at least my understanding is, forget Nexus. Then this Nexus is in the picture. Then we go back to the original JVA, which they had through all of this time been finding ways to inform us that they are not accepting it. Okay, and not only this, they tell us to put the required capital, and they gave us a time frame which is not part of the existing JVA. So not only are they sending us back to the JVA, but they're putting new terms for us. And even if we were to go and say, okay, the required capital, what is the required capital? Based on what scenario? Because each scenario in the joint venture agreement as amended had a certain capital requirement. So this letter not only just basically came out of nowhere. I go after this letter, a day or two later, I can't remember how many days later, I sit with Mr. Nabil Al-Kindi, who is still telling me of how we're going to develop this project. And I already explained to you what happened then, that when I informed him, but we received the letter. He had no clue. He went and spoke to the legal team, and he said, yes, we did send that letter. And then he asked if I wanted to sit with the legal team. At this point in time, after wasting my own time for 4 years, traveling to Dubai very often, traveling from the US to Dubai to try to make a settlement agreement, all of a sudden we get this piece of paper as if everything that I've been doing is down the trash.
All right, let's try and unpack a little bit of that, shall we? First of all, you said that this was news to Mr. Al-Kindi. Can you turn back, can you go back to, keep this letter because we'll come back to it. But if you can go back to Bundle F, Volume 6, and find page 3114, please. You'll see it is tabbed 329.
Okay.
Do you have page 3114?
Yes.
Do you see there an email from Mr. Visser? You will not have seen this at the time, to Mr. Nabil Al-Kindi, and it's dated the 8th of October 2018, and it says, do I still proceed with sending the demand letter to Nexus and Hexagon? And Mr. Al-Kindi's response is just above, please go ahead. We need that moving so they don't act. What?
Sorry, 3114 is not what you're reading.
F3114?
Yeah, that's not what you're reading.
I'm starting at the bottom of the page, yes? Starting at the bottom of the page, Mr. Gosson.
Do I still proceed with send? Okay, now I found it. All right, okay.
See it? Yeah. So Mr. Visser is asking Mr. Al-Kindi, 8th of October 2018, do I still proceed with sending the demand letter to Nexus and Hexagon? And then Mr. Al-Kindi responds the next day, please go ahead. We need to have that moving so they don't think we are slowing them. Thanks. So Mr. Al-Kindi knew all about this letter, didn't he, from this?
In my meeting, it was very clear that he had no clue about this letter. Of this, I don't know what this is. Or either it was this or it was a very nice show that he put on, because he literally and genuinely showed me that he had no clue about this letter. And even he went out and he checked with the legal team and brought in and came back and said, yes, and why don't you sit with the legal team?
Mr. Hosson, are you embellishing your evidence to try to present a more convincing picture about this letter?
Sorry?
Are you embellishing your evidence to try to present a more convincing picture about this letter?
Not at all. I'm just very disappointed at the time I spent and the effort I made to all go in vain, because we genuinely and truly were negotiating to do a settlement agreement and develop this project. And I wasted a lot of my time and energy to try to make that happen.
All right, but your complaint is that you thought you were close to settlement, but now in this letter, there, I think the words you used were sending you back to the JVA. That's your complaint, isn't it?
Mr. Hossain and Mr. Montague-Smith, I'm sorry to interrupt. I've just seen an implored message.
Yeah, that's thank you, my little friend. I'll keep an eye on that. But thank you very much for the intervention. Thank you. It's very kind. Thank you. For the
Look, if the IFC, the question is still there.
Yes, please. Let's go back to the question before the intervention. And the question was, your complaint about this letter was that it was sending you back to the joint venture agreement. And when you thought you'd done a settlement or you got close to a settlement. That's your real complaint here, isn't it?
No, my real complaint is the lack of transparency. The lack of transparency that was showed by the DIFC. Because after all of this negotiations with them, and after all that we've been through with them, the least they could have done is kind of brought us into a meeting, like they bring us into a meeting every other time, and explain to us what it is that they're doing. Instead of just sending this letter just off the bat, okay, here, take a letter and go back to the original joint venture agreement. And when all of this time they've been saying no, well, what do you expect my reaction to be?
Can you look at page 3119, please? So this is the cover email that was by which the letter was sent to you, isn't it?
Yes.
And do you see it's an email from Mr. Visser and it's copied, I think, to you? Yes?
Correct.
And so they say, Dear Jawad, your email below has reference. Given that the settlement discussions ongoing in this matter have not produced any mutually agreeable alternative outcome, we have decided to proceed with the original transaction as agreed in the joint venture agreement dated 14th December 2003 as amended. So they did explain to you why they wanted to go back to the joint venture agreement, didn't they? It was because you had not reached a settlement agreement that was mutually agreeable.
At this point in time, and after the letter, for me, this became a legal issue. I backed out because I had reached a settlement agreement. And here he's re-emphasizing the fact that we have not reached a settlement agreement. And in that letter, by the way, there is one thing that I forgot to mention in that letter that we were discussing earlier. They want us to implement something that they themselves said was not viable. So can you imagine my reaction to negotiating and coming to this conclusion after all this time I spent in the negotiation? So after that letter, to be honest with you, I backed out. I was no longer involved. It became a legal dispute. And from then and on, it was King and Spalding and the legal team taking care of it.
But if we're looking at the letter itself, you mentioned the issue of viability. Viability was about questions of mixed use and so forth, yes?
Yes.
And the letter doesn't say anything about mixed uses, does it?
No. I'm just saying. I'm telling what my personal. I'm telling you what my personal. What my reaction was. I'm not saying what's written in this letter. I'm saying what my reaction was when I saw this letter.
Yes, but the letter is telling you what they want to do going forward. They want to go back to the terms of the joint venture agreement, don't they? Yes.
And they want to also to inject the project capital, and they want to give a certain timeline, which is not in the joint venture agreement. And they don't mention what the capital requirement that is needed, and they don't mention which scenario of the joint venture agreement that we're supposed to inject the capital.
Yes. So,
from my understanding, sir, when this letter was issued, okay, I was working a settlement agreement, which culminated in a favor. This letter was produced. I was no longer involved from the minute this letter was produced and going forward, because no settlement agreement had been reached.
yes, all right. But so when it says that you complain about the proposals about financing, don't you? But wouldn't you read that letter where it says DIFC proposes that such liquid finance be provided within 3 months as inviting Hexagon to come back and make some further counter proposal? Isn't that how you understood it? No.
Not at all. And again, I repeat, we had a clean means of communication with the DIFC. The least they could have done is after all that we've negotiated and we've been through, to bring us to a meeting and explain to us what they have in mind and how they want to proceed forward. Not send a letter by email, by fax, I don't know how they sent it, without any explanation.
And can I ask you to go forward in the bundle to tab 331, please? In the right place. 31. Yeah. Do you see there an email from yourself dated 14th of October 2018, and you email to the Al-Majid brothers, the other shareholders? Yes, you see that?
Yes, I did.
And what you say there is, please find attached the letter sent by DIFC, in which they clearly acknowledge the 2003 joint venture agreement as amended, and they are requesting to proceed in accordance with in accordance to the 2003 joint venture agreement as amended. So yes. Your understanding of that letter of the 10th of October was that it was a request to proceed in accordance with the original agreement, wasn't it?
No. I was just sending, because I was exiting from my duties to reach a settlement agreement, I was informing the parties of where we had reached at that point, and everything after that became a legal issue. After this point, I just sent them that these are the facts, this is what they sent, and I excused myself from any further negotiations or involvement in this case from trying to reach a settlement agreement. And then I repeat myself, we had a very clear means of communication with the DIFC. The least they could have done is requested a meeting to explain what it is that they are doing and how they are going forward with this, if that was the intention.
But you describe the letter that they sent as a request to proceed in accordance with the 2003 JV agreement as amended. That's what you understood the letter to be saying at the time, didn't you?
Well, there was a request, but that request, whether that request was reasonable or unreasonable, I did not state. I just simply said it was a request. They want to go back to the joint venture agreement. You decide what you want to go on to do from here. Because in that letter in itself, there was a lot of things that did not make sense. There were conditions that were put there that were not part of the JV agreement, and there was still a lot of uncertainty resulting from this letter. So rather than creating clarity to go forward, we get this letter to create a whole new confusion. And you know, this scenario of reaching something and then falling apart, and then reaching something and then falling apart has been ongoing from way before my time. So I spent 4 years, and before me, many people spent time, and this was the same cycle going over and over and over again. We wanted to develop this project. We wanted to execute it. And then we get to an agreement. We reach a climax of an agreement. We think we're going forward. And then something comes blindsided out of nowhere. Nothing to do what we were talking about. Nothing to do with the discussions that we were having.
And when you received that letter, going from the discussions that you'd had with them, you did not have any doubt that it was in fact what they wanted to do, that they wanted to go back to the joint venture terms from 2003, 2004. You didn't have any doubt that was their intention. I
had way too many doubts, but I don't want to get into making assumptions and presumption and all of this. I mean, I have a lot to say about that letter, but these are personal opinions that I do not wish to disclose. But I don't think that the intention of this letter was very transparent and clean.
I want to ask you about a different issue, if I may. Bear with me one moment. Can I ask you to look in your witness statement at paragraph 85, please? And in the middle of that paragraph, you say the UBOs, those are the ultimate beneficial owners, so the shareholders of Hexagon, the ultimate shareholders of Hexagon. The UBOs themselves were and remain individually wealthy and collectively would have been able to finance the project personally if the DIFC vetoed all other options. Now, I want to ask you about this. You are a representative of Mr. Romaizan, yes?
Correct.
You still represent him?
I still do.
I see. And it's fair to say, isn't it, that you can't speak to the finances of Mr. Papadopoulos, for example?
No, I cannot speak to the finances of Mr. Papadopoulos.
And you don't have any direct of the...
Although what is known to me is that he's a very successful jeweler in the UAE.
All right. But you have no direct knowledge, for example, of the Al Majid's personal finances either, do you?
No, but I know that they're very prominent, they're very wealthy, they have a lot of developments in Saudi Arabia, which are very successful, some of them superseding the size of this project by multiple times in Mecca and Medina. So I know a general understanding of them, but I do not know their specifics. But I know that they're very capable.
By repute?
By reputation, yes.
And presumably you have some, presumably you're not saying of Mr. Romaizan that he had $400 million in cash, for example, just lying around in a bank account.
I'm sure he had more.
You're sure he had more? Do you know how much he had?
No, but I can tell you one thing, that when Mr. Romaizan entered this phase of the negotiations and he took the lead, he was willing to do anything needed to satisfy the demands of the DIFC. So even if in the early stages when we wrote to Her Excellency Riemann Hashemi, we thought that there might be a concern about 10 miyat. So we even wrote in that letter that we are willing to do the needed. And even when Mr. Visser had questions or had a halo surrounding Fayez Papadoulos, who is already in the UAE, and he mentioned that there's something not correct there, we were also willing to take care of that. Mr. Romaizan was willing to do anything that's needed to make sure that this project gets developed, be it to deal with his current shareholders if they had any problems, or to come up with the financing that he needs. And I mentioned earlier that it's not an issue of having liquid finance or not liquid finance. In our cases and in Oman as well, he managed to get financing for a multi-million, more than 300 million, based on his personal guarantee. So it's not about liquid finance also, it's his capability of attaining project facilities based on his personal net worth and contacts.
And in your witness statement, you say they had excellent relationships, talking about the UBOs, with a number of banks in the region, including in the Kingdom of Saudi Arabia, who could have lent them money based on a personal guarantee or collateral other than the project land. Now, again, I mean, you do not have, presumably, direct information about precisely what assets Mr. Romaizan owns, do you?
I do not have an access of everything he owns, but what I know of what he owns supersedes what is required for this project by multiple folds.
And those sorts of assets are presumably shareholdings in companies and things of that nature. Is that what you're suggesting?
Banks, shareholding in banks, properties, shareholders in companies, you name it, across the board.
And so you've said, so in terms of banks, there would be statements which would show how much money was in each of the accounts, wouldn't there?
Well, there'll be a statement that he is capable of financing this project. You don't need a number there, do you?
I beg your pardon?
The bank would say that he's capable of financing. And that question was asked to me many times in the discussion. And I confirmed in every single instant that we are ready to finance. We are ready to finance. We have the money to finance. I don't even know why this keeps coming up. And as I mentioned earlier, anybody that does a very basic due diligence about Mr. Romaizan, for example, he will see that he's more than capable of financing this project on his own, let alone the other shareholders.
Isn't it right that in the course of your negotiations with the DIFC, one of your priorities was to achieve terms which minimised the cash requirement up front that was required from the shareholders?
It was a suggestion. It wasn't written in stone, and it's not a prerequisite. We were saying this is what we would like. It was up to them and come and say, okay, you can do this, you can't do that, because the joint venture agreement as amended is very clear in terms with regards to the financing.
So you do accept that you suggested that the conclusion of the negotiations should lead to a situation where there was minimal upfront cash investment by the shareholders?
No.
I see. All right. What is it also correct that in meetings with Mr. Visser, you described this negotiation as a loss mitigation exercise for Mr. Romaizan?
Can you repeat the question?
Isn't it right also that in meetings with Mr. Visser, you described this negotiation as a loss mitigation exercise for Mr. Romaizan?
This negotiation period was a waste of time.
Yes, but what you were trying to do through the negotiations was mitigate a loss for Mr. Romaizan. That's how you characterized the negotiations, isn't it?
No, this is for Mr. Romaizan. This particular case or situation, let's say use the word situation, had two aspects to it. It had an aspect which is the financial aspect, but there's also the aspect of principle. This investor, who is very I don't know what the word to use, but principles mean a lot to him. This guy bought the rights to develop a property very clearly, very transparently, and his rights were not, he was not able to do it throughout this period of time. So at the end of the day, when he was finalizing this negotiation, it became a matter of principle. Either you're going to allow me to develop this land, because that's my intention, or I'm going to have to go to court. Now, in parallel to the principle of developing the land comes the issue of the financials. And as I mentioned, they truly believed in this plot of land. They truly believed that this plot of land is a jewel and it was going to give them good returns because they know the land, they're part of the GCC, they've seen the cycles, they've lived Dubai from the day it was initiated all the way to today. And they are property, real estate people in the end of the day, and they believe that this plot of land genuinely was going to be a jewel for them that would give very favorable returns.
My lord, I just need to inform you that I need to withdraw one of the questions that I previously asked because I've been corrected. The premise of the question was false. I suggested to Mr. Hosson that he had described the negotiations as a loss mitigation exercise. In fact, it was not him who described them in that way. So I just needed to make that clear. I'm not sure I ever quite got an answer to the question, but I didn't want it to go forward on the basis that that was my case. Okay. Thank you, Mr. Hosson. I just have one or two further questions. When you were discussing with Deloitte these models for how the joint venture was going to proceed, you asked them to look at ways of minimizing the upfront cash investment in the project, didn't you?
I don't recall that I asked them this very specifically.
You don't recall. All right, let me show you that then. If we go to, I think it's the same bundle, it should be paid, tab 306.
Go ahead. Can I
So do you see there an email from Mr. Oliver Morgan dated 29 May 2018? And now he is one of the people at Deloitte who was conducting the study, yes? And it's dated 20. So, and it's an email to you, and it says, "Dear Gaith, further to your request below, please see the attached, which is structured to answer your queries as requested. We have reviewed the base case scenarios where escrow cash is used to fund the project to minimize the shareholder equity commitments." So isn't it right that one of the priorities that you were given in your negotiations was to minimize the shareholder equity commitments?
No, what we were doing here is basically looking at different scenarios. One of the scenarios was that in case we used the escrow cash to fund the project, because that was one of the discussions we were having with the IFC. It was never a very clear statement that we wanted to reduce or minimize. It was just different scenarios that we were going through.
Thank you, Mr. Hosson, for your patience. My lord, those are all my questions.
Thank you. New examination, Mr. Springe?
No re-examination, thank you.
There's just one question I'd like to ask you, Mr. Hosson. Can you go to bundle F4 and page 2133?
I believe it's tab 262, my lord.
Tab 262, yes, thank you. F4, tab 262.
Yes.
This,
Go ahead, Father.
this is your note of the meetings which took place with the governor on the 16th of May and with DIFC on, it's either the 17th or 18th of May. Probably the 18th if the letter referring to the meeting is right. You refer to this in your statement, but as far as you're concerned, this is an accurate note of things that were said at that meeting?
Yeah, so the under the first title
Yes.
is the what happened with the government. Yes, this is my recollection, because after each meeting or the meetings, I would go back and report to my principal. So I would jot down notes as to what happened, the basic things, and these were my recollection at the time.
Well, I'm sorry, was it a note you made actually at each of the meetings or immediately after the meetings?
Immediately after the meetings.
Right, very good. All right, that's all I wanted to ask. Do either council want to ask anything arising out of that?
Not from me, my lord.
Nor me, thank you.
No, very good. All right, thank you very much, Mr. Hosson. Those are all the questions, so you're free to go. Thank you very much.
Thank you. Bye-bye.
Right. I withdraw my lack of confidence in your estimate of time, Mr. Montague Smith, at least on this occasion.
I'm grateful.
Very good. Well, there's no point in even thinking of beginning a witness now, even if one was available, which I doubt.
Yeah.
Presumably it's a Monday start with the defendant's witnesses.
My lord, yes. I must confess I'd stood down Mr. Brazi, and I was going to throw myself in mercy if we'd got through Mr. Hosson earlier, but there we are.
Well, there doesn't seem much point in beginning now, and I'm sure people would be quite pleased to, particularly those in Dubai, if they can go and have some dinner or something. So in what order are they appearing on Monday?
So on Monday, we will have Mr. Bisha Barazi. He's the
Right.
first witness. And then after him will be Roberta Coloresi. And then after her will be Jacques Visser. Now, as it's programmed, we have 1 full day set aside for each of them. It seems doubtful that they will all need 1 full day, but we're obviously in my learned friend's hands on that front. So as the programme stands right now, we've got a timetable, my lord. I don't know if you've seen it.
I have.
There's a bundle L.
Yeah.
Yeah.
That's,
We're one day behind where we thought we might be. There's tab 8 of that bundle.
yeah, I've got it.
It seems to me the priority really is to ensure that if we can, we get through all the evidence next week.
Yes.
And subject to anything my learned friend has to say, that seems to me to be a sensible ambition. But that does rely on council's estimates being reliable.
And any predictions, Mr. Strange?
Well, I definitely want to get a gold star for my estimation, so I need to think about this over the weekend a little. But I do agree with Mr. Montague-Smith that we will get the evidence done next week. I do agree that we're unlikely to need a full day for all 3 fact witnesses. My feeling is that the first one will take the longest, but then they'll get quicker thereafter, and I think the 3rd fact witness will probably be the shortest. So my estimate is that I think I can finish the fact witnesses by Wednesday, and maybe even have the first of the experts on Wednesday afternoon for the
Yes.
the second session.
Yes. Well, without preempting anything, I mean, as I understand your case, I mean, the reality is that subject to any points you want to put about good faith, the negotiations by way of settlement, they speak for themselves insofar as they're on paper. And
Yes.
we don't advance your case very much because they didn't arrive at any result.
Yes. I agree. I mean, if we're putting this case into 2 halves, it's the first half where most of the action is.
Yes. Or inaction is.
Right. Exactly. Yeah,
right.
But yes, and that's why my estimate is that certainly the first witness is the most important and will take up the most time. So yes, and as your lordship knows better than all of us in this room, as the key witness gives evidence, things that you need to put to the witness as subsequent is less important. And I think the final observation I would just make is, I think Mr. Montague-Smith quite rightly hasn't followed the old school approach of putting every single point to the witnesses, and I certainly don't intend to do the same thing. I mean, we will focus on the issues that we think are pertinent to the key points in the case. We don't intend to go through every paragraph and challenge each witness.
No. Well, let's focus on what's relevant. And the experts themselves, how long they really expect it to take. I confess I still haven't got grips with the experts at all. I will try and do something with them over the weekend, but it may be that actually we might take a half day out in the middle of next week so that I can educate myself on what the experts have to say. But we'll see if that works out. I mean, are you expecting it to be a long time with each of the experts or not?
I mean, from my perspective, it's a half a day.
Right.
I think my estimate was a day, but that was a pretty uneducated estimate. I'm a bit hesitant to tell you that it's going to be much less than that, given there is a bit of a shopping list of points to deal with. But I think it's safe to say a day for each. And right. if my learned friend finishes half a day early, then that will give us the half a day reading time. But I mean, yeah. And if he finishes a full day early, we might well think about having a reading day.
well, let's see where we get to and what chance I have. One of the advantages of an early start is that one has time at the end of the afternoon in London time. You know, can read till late in the night if need be. But at present, what you would still want to do, assuming we finish the evidence next week, is to take then a couple of days out before making closing submissions. Is that right?
Whether it's a day or 2 days, I don't mind. It seems to me that taking at least a day will help us put our thoughts in order a bit more carefully, and perhaps even have half a day off. But those are the lesser priorities.
And were you contemplating putting something in writing or not putting something in writing by way of closing submissions?
I think I had in my mind something very brief, just for you to look at. The difficulty with that is that then requires us to get that to you in advance, so you can have a chance to look at it, my lord. I certainly hadn't contemplated any sort of comprehensive, detailed written closing, whether before or after oral submissions. But it really, we're in your hands, my lord, as to what you would find most helpful.
From my perspective, the only thing we had in mind was a short speaking note, and the main point of that would be really to put all of the key references for the key topics for you in one spot. So that was the only thing we had in mind, but I agree that would be brief, and it certainly wouldn't be a post-hearing submission like we see in arbitrations, or even indeed in the commercial court. It'd be much more shorter than that.
Yeah, well, a sensible speaking note, I think, might make sense, which doesn't necessarily require me to have read it in advance to any significant extent. But there is a question of wood for the trees here. In this case, there's a lot of detail which, to my mind, doesn't really advance either party's case very much. So I'm looking for real focus when we come to closing submissions.
Yes, my lord.
Right.
I mean, obviously, where the focus lies may depend on what's in your mind. So the more of that we have access to, the better. And of course, your lordship isn't going to prejudge any of the issues, but having made that observation, it certainly would help me to know a bit more about what your thinking was before we embark on that process.
Yes, well, of course, I haven't heard from the defendant's witnesses, and good faith appears to be an issue. So that element appears there. But if one simply looks at the terms of the AJVA, which is the only agreement which is accepted as being binding by both parties, you look at the terms of clause 3.2, and it's clear that that's a qualification of all the obligations in 3.1. And to establish a breach of that obligation, even allowing for the word immediately in relation to the incorporation of the joint venture company, requires Mr. Sprange to go quite a long way. And as I understand its case, you know, it has to cover the position which is essentially 2006 through to 2012. He has to show that there's no time bar operating in relation to the matters of which he complains. And at present, I don't see how the case on renunciation works at all once it's been withdrawn. But I wait to be educated on that subject. But given those preliminary indications, you'll see that I think it's the evidence in relation to the early years that matters.
That's very helpful. Thank you very much. And of course, we understand that that doesn't indicate that you've made up your mind on any of that. But I'm grateful for that.
Of course not. And in particular, if one's looking at good faith, the question of how the defendant's witnesses appear and how that reflects on DIFC's good faith may matter.
Thank you.
That I understand. I'm also would value some help at the end of the day, Mr. Sprange, in relation to the the unpleaded points, if I can put them that way, in relation to GFA and mixed use and so on. When we discussed this at the outset, I said my understanding then was that all this was evidence which was said to be reflective of, if not bad faith, lack of good faith, or something similar. But if there's more to it than that, then I need to know.
Understood.
At the end of the day, you've got to show the breaches you allege in paragraphs 18 and 19 of your amended points of claim. That's what it comes to.
And 22 and 27B.
Which are, just remind me what they are.
They are alternatives later in time. Some before, leading up to 21-22 is leading up to sort of the 2012 period, and the June letter and the events post that, and then 27B is sort of the post 2012 insofar as it's anticipatory breach.
Well, there's on Mr. Hoson's evidence, any further renunciations have gone, haven't they? And even if they were there, it's all withdrawn by the time we get to, at least to the letter of October 2018, if not before on some of the documents upon which Mr. Hoson was cross-examined today, where his answers, I'm about to say, were less than satisfactory. Anyway, that's how it stands in my mind at present, but please don't feel in any way inhibited.
No, understood. And the position on those events post 2012 involved two sides of a coin, and we've heard one side.
Yeah, no, I understand that. That's why I say I wait to hear the defendant's evidence. All right, very good. Then usual time on Monday morning, afternoon, whichever it is, wherever you are.
Thank you.
Very
Thank you,
good.
Lord.
Thank you very much.